I am praying for listing of a bail application, madam. Last Monday, your lordship, I have praying for listing, my lord, your lordship allowed for today, but not listed, my lord. So I am praying today, my lord, for Friday.
Friday.
My lord, bail application on similar case was already granted bail by this court, my lord.
Okay. Okay.
Friday, my lord. Obliged.
May I please, Mr. My lord, item number 13, my lord. As per information, my lord, there is no updated CD and FSL report, my lord. So, my lord, contact may be given, my lord, because, my lord, it is pending since last.
Mr. What is your name?
Hussein.
Hussein.
My lord,
Also.
earlier CD was there, updated CD not received today, and with the FSL report. Commercial quantity from South Salmara. Asking for.
Also, Mr. K.K. Parashar, who prays for some more time for producing the updated case diary. The prayer is allowed. Let this case be listed again on 13th.
My lord, mainly in this.
No.
The first week of August, my lord.
7th.
Obviously.
7th of August.
May I please, so I beg to mention for listing of a bail application also, it was last listed in the month of June, Lordship. Immediately after vacation, the order was there, but it has not been listed.
What is the matter?
It is under Buds Act, Lordship, Buds Act, and all the co-accused have been granted bail. But he is behind, Lordship. Can it be on Friday, Lordship? Already more than 8 months, Lordship, he is behind.
Okay.
LCR has also come, Lordship.
Okay.
On Friday, Lordship. Deeply obliged.
Lordship, in item number 37, to file an affidavit in objection, Lordship, for the informant, we are for the informant. So can you record when we call for on Monday, Lordship, we filed.
On Monday?
14th we filed the
Call for the affidavit.
Please, Lordship, I beg to mention item number 28, Lordship. Lordship, CD is not received.
28. Heard Miss
L. Burwa.
L. Burwa, Learned Counsel.
Continue.
Learned Counsel for the petitioner. Also heard Mr. K.K. Parashar, who prays for some more time for producing the case diary. The prayer is allowed. List this matter on 5th of August. The interim order shall continue till next day.
In item number 5, Lordship, I want to file an additional affidavit, Lordship. So this matter may be passed over for the day, Lordship.
Heard Ms. T. Som, Learned Counsel for the petitioner, who prays for allowing the petitioner to file an affidavit, additional affidavit, and therefore prays for adjournment of the case today. The prayer is allowed. Let this matter be listed in the next week.
And
May I please, Lordship, I wish to mention for listing on anticipatory bail application on tomorrow, my lord. There is an urgency, my lord. The IO issue a notice under section 35A.
When have you filed?
Yesterday. It was already numbered.
It will automatically come.
Lordship, automatically come, it will be come on Friday ballot, but Friday date was fixed by the IO to appear before him.
Okay. Tomorrow.
Obviously.
Yes, please, Your Lordship, it's an NDPS matter, 22C, read with 29. The main accused has been given bail. My DA is pending. Paying for listing for tomorrow.
When have you filed?
It's been 2 months, 22/5. It's pending. It was fixed on.
What was the last date?
On 14th, but it didn't come on 14th.
Okay.
Fixed for CD? Yeah, on 14th. No, not for CD. It was for the medical record was called for from the.
What was the next date fix?
On 14th, Your Lordship.
14th of.
On 14th of July.
On 14th, it was not listed.
Not listed.
Okay.
Much obliged.
item number 35. Lordship, my senior is suffering from fever. I kindly adjourn the case for today and fix it on 18th of July.
Item number 30?
30.
35. 35. What is your name? Heard Ms. P. Majumdar, Learned Counsel for the petitioner, who prays for an adjournment on the ground that who is indisposed? Mr. I.C. Dekka. That on the ground that the conducting counsel for the petitioner, Mr. I.C. Dekka, is indisposed. Considering the ground, the prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
Wait, Your Lordship, I beg to mention for listing of a matter today at 2, anticipatory bail application. What has happened is, Lordship, I am a MBBS graduate. I am not a doctor. I have never practiced as a doctor. I have applied for my registration before the Assam Medical Council.
When have you filed?
We have filed it today. We have called the serial number, my lord, at 2. my lord.
No. No. Tomorrow.
Obligation. If Your Lordship permits, police has been harassing my family members also. My entire career will be doomed, my lord, if I am arrested, my lord.
What do you want now?
I want for listing at 2, my lord, if Your Lordship permits, my lord.
Tomorrow.
Obligement.
My pleasure, Lordship. I beg to item 8 for admission for possible for the day. So, due to personal difficulty, senior counsel.
Item number 8.
8.
Heard, Mr. What is your name? Be louder.
MDS Ali.
MDS Ali, learned counsel for the petitioner who prays for an adjournment on the ground of the personal difficulty of the conducting counsel for the petitioner. The prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
Wait, please, Your Lordship. Lordship, I would like to mention item number 46, Lordship. In this connection, Lordship, I have filed an additional affidavit, Lordship. Let the affidavit may be called for, Lordship.
Yes, call for the affidavit.
And this item can be taken up at 2, Lordship.
No.
46, Lordship.
Okay. It is a motion item.
Motion item, Lordship.
Okay, at 2.
Highly obliged.
May I please, Your Lordship, I beg to mention AB 144/1/2025. Lordship may kindly place the matter tomorrow or on Friday.
Why?
We have filed this application on 25/6, last June only.
When it was listed?
It was listed on 25 June, but it was missed. Like I was busy in another.
Or what is the next date fixed?
No, date was not fixed.
What was the order passed by the court on last occasion?
Order was to list after the vacation.
So it will be listed
Lordship, may kindly tomorrow or on Friday.
tomorrow or day after tomorrow. We may have reference, so we will have less time. On Monday also, on Tuesday.
On Tuesday. Much obliged, Lordship.
It will listing of a bail petition on Monday.
What is the matter?
The accused has been arrested under the Arms Act.
When have you filed the petition? So it will be automatically listed unless you have filed it yesterday. Wait for 2 days. If it is not listed, then you make a mention.
May it please, Your Lordship. I prayed for listing of a bail application, which was last listed on 17/6/25.
What is the matter?
It's a NDPS matter. bail.
What was the last order passed?
After vacation, it should have come and
Tuesday.
on Friday, Lordship.
No.
There is no notice.
Tuesday. NDPS matter.
It's been 200 days behind bars and there is no notice, Lordship.
Then next Tuesday, Tuesday.
Much obliged.
With the Lordship, I beg to mention item number 36, Lordship. On the consent of the other side, Lordship, kindly fix this matter after 2 weeks, Lordship.
Item number 36. 2 weeks, why?
Lordship, engaged counsel, Mr. S. Mani is not well. He could not appear.
Okay. Heard, Mr. What is your
A.
name?
Sharma.
Heard, Mr. A. Sharma, who prays for an adjournment on the ground of indisposition of the conducting counsel for the petitioner, Mr. S. Munir. Considering the ground, the prayer is allowed. Let this matter be listed after 2 weeks.
Lordship, I'm on interim, Lordship.
The interim order shall continue till next date.
Lordship.
Your Lordship, I beg to mention item 10 of daily list. The matter will be taken at 2 p.m. Your Lordship.
Why?
My senior is suffering from some fever and she will reach at
At 2, he will be okay.
take some time because she will go to the doctor.
Okay, at 2.
Yes.
May I please, Your Lordship? I beg to mention item number 37 of today's list, Lordship. In this matter, Lordship, this case diary has not been received as of now.
Heard Mr. M.K. Das, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Let this matter be listed on 6th of August.
Interim may be
The interim order shall continue till next day.
deeply obliged, Lordship. May I please? I beg to mention relation to the for adjournment.
Okay, when?
18 November.
Okay.
Obviously.
Wait, please, Lordship. Lordship, item number 40, may kindly be adjourned for that day. May kindly be fixed on 21st of July. Lordship.
Heard Mr. M. Rahman, learned counsel. 21st is Monday.
Monday. Lordship.
Monday, we will have less time. Tuesday.
Friday.
Tuesday.
It's Friday.
Tuesday.
So Tuesday I will not be here.
Wednesday. Heard Mr. M. Rahman, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty, his personal difficulty. Stop. Considering the ground, the prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
I'm playing for listing on anticipatory bail application, Lordship. I have filed it on Monday, and on Monday itself, Lordship, the case was registered. Here, Lordship, the petitioner is a government servant, Lordship. He is a government officer, Lordship, apprehending arrest in connection with a disproportionate of asset.
When do you want?
Lordship, kindly tomorrow, Lordship.
Okay.
And
Therefore, listing of a bail application, madam. Can it be tomorrow, madam?
It is a fresh matter.
No, madam, pending matter.
Pending, let it be on Tuesday.
Tuesday, madam.
Tuesday.
Hello.
There is Muslim item 1.
May please, Lordship. This is a regular bail application. And today, my lord, the petitioner has completed 90 days time, my lord. Today 93 days, my lord. So yesterday the period is over. So for the fact is concerned, my lord, there was a lave share.
Whether charge sheet has been laid. Charge sheeted case. It is a charge.
Petition file it is transmitted on 26/5/25.
You have paid. File your bail application before the trial court.
My lord, that may be considered, my lord.
Heard Mr. What is your name?
Ali.
Ali, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that in this case, charge sheet has already been laid bearing charge sheet number
20/2025 dated 26/5/25.
In view of the fact of laying of the charge sheet, this bail application is disposed of with an observation that the petitioner may approach the trial court and may pray for regular bail before the said court, if so advised.
My lord, that may be considered, my lord, problem.
It will be considered. You file.
My lord. That observation, my lord,
Not necessary.
my lord. Item 2, Lordship.
Wait, please, Lordship. The charge sheeted matter, madam, anticipatory bail application, madam. Matter relates to my Cattle Preservation Act, madam. 6 cattle, madam, were recovered from a Bolero pickup, madam. The
Charge sheeted matter.
charge sheeted matter.
Why anticipatory bail?
Anticipatory bail, madam, the thing is that we received summons from the court of SDGM, madam. And these Cattle Preservation Act matters are tried and exclusively by the Sessions Court, madam.
But what is the punishment?
Punishment is 8 years, madam.
There is no embargo in granting bail.
Since, madam, we were illegally shown as an absconder, madam, in this house.
Still, there is no embargo.
Yes.
And
Cattle was already recovered, madam. So,
no, this you have to convince the trial court.
madam. And
There is no reason for filing an anticipatory bail in this case. You justify how anticipatory bail is maintainable in this case. It is not maintainable because the court which issued summons to you
Yes.
is empowered to grant bail. There is no embargo on that court.
But if we go by section 209 of
Huh.
the Code of Criminal Procedure, madam, that says that while committing the case, madam,
Subject to provision of bail.
bail.
So there is no
No
embargo.
embargo. But since this is a matter which is tried by the Sessions Court, so there are good grounds that we may be denied the.
No, no. This
But
is
the
only
bail-
your apprehension without
Yes.
any legal basis.
Since
You satisfy me that this bail application is maintainable. I'll grant you bail. Otherwise, either you withdraw or I will dismiss it.
Can it be on Monday, madam?
Okay. Heard Mr. S. Das, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. On request of learned counsel for the petitioner, on Tuesday,
Monday.
let this case be listed again on 22nd July 2020.
I'll leave this.
Please allow this. Well, this is an anticipatory bail application under section 482. Because the petitioner is a government employee. Well, he is working as a block development officer in Mechuka, in Arunachal Pradesh. Plus, what had happened in 2012, the government approved a sanction and work amounting to rupees 18 lakhs odd for construction of a yak farm in Mechuka. Well, it's pursuant to
The vacations are going on in
Yes,
Itanagar
the
bench.
vacations are going on. It will reopen on 20th March.
Okay.
Well, it's, thereafter, the petitioner, being the block development officer, he issued a work order to a particular contractor. The work was carried out, Malaj. But what had happened, Malaj, the fund which related to the work was for that particular financial year of 2011 and 2012. So the fund would have lapsed on 31/3/2012. So initially the fund was placed with the deputy commissioner. What the deputy commissioner did was, since the fund would have lapsed on 31st of March, so he placed the fund in the account of the BDO so that it would not lapse. The work was completed and the payment was made on 13th of April 2012. What the block development officer did, the petitioner hearing was, he had made a payment of 13 lakhs by check, and the remaining 5 lakhs was paid by way of a money receipt. So after more than a year of this completion of the work, a person comes forward claiming to be a RTI activist, and he files an FIR saying that this particular, there is misappropriation of funds relating to that 5 lakhs or that has been paid by way of money receipt. So a case is registered in the SIC Malaj and an investigation is undertaken. Malaj. The petitioner hearing has all along participated in the investigation. Malaj. His statements were recorded. He has produced the documents. The investigation was ongoing from 2013 to 2025. So petitioner has all along participated. He is not shying away. So prosecution sanction has also been issued on 5th of July, Malaj, 2025. So after the issuance of the prosecution sanction, Malaj, the inspector, Malaj knows in the Prevention of Corruption Act, as per section 17, proviso to section 17, the state can issue an order saying that the inspector of police can investigate or arrest without the order of the magistrate. So that particular order has been issued by the state of Arunachal Pradesh on 12th of March.
Where is that order?
There is at page 26. Last page of the bill application was. May I read this?
Yes.
In terms of section 17 of the Prevention of Corruption Act 1988 and supersession of so-and-so, the government of Arunachal Pradesh hereby authorizes inspectors of police in the Anti-Corruption Bureau under the Vigilance Department to investigate offences punishable under the said act. This authorization includes the power to make arrest without warrant.
Yes, this power has been given.
Yes.
But is there any attempt?
Yes, the inspector of police has been calling me, Malaj, to come to the police station. So I apprehend that I may be arrested. But at this stage, custodial inspection, interrogation may not be required, since the investigation has been going on since more than 12 years. Malaj. I have all along participated.
Where is the FIR?
The FIR is at page 13. Malaj. Page 14, Malaj, sorry. The FIR is dated 27/5/2013. It has been registered under section 13(1) and 2 of the Prevention of Corruption Act. I do not have the copy of the complaint, Malaj. Malas will in fact find this prosecution sanction at page
No,
21,
no, where is the FIR?
page 14.
14 is the form.
Because I do not have a copy of the complaint, so I could not annex it, Malas. But the entire facts have been recorded in the prosecution sanction.
Where is the prosecution
That
sanction?
is at page 21. Yes, Malas, got it. May I read this, Malas?
Read the relevant part where the accusation has been made.
Yes, Malas. Paragraph 3, Malas.
Yes.
Whereas from the FIR and the other enclosures, it is observed that the complainant collected the relevant documents through RTI in which the complainant lodged FIR to the Commissioner of Vigilance, Government of AP for vigilance inquiry into the case. Accordingly, the complaint was endorsed to the Inspector S.K. Thongdong, Vigilance Branch, AP Secretariat, Itanagar to conduct.
What is the date of FIR?
27/5/2013. To conduct inquiry into the matter. The inquiry has been conducted by the inquiry officer, and after due completion of inquiry, he submitted inquiry report to the Commissioner of Vigilance, Government of AP Itanagar, along with all relevant documents, and suggested a regular criminal case may be got registered by
Yes,
the
Mr. Chandra.
Lordship, I have got this instruction, Lordship. I'd like. Lordship, may peruse the second page, Lordship.
Yes.
The investigation of the case has been completed. The instant case was pending for receipt of the prosecution sanction against the three alleged officers, namely so-and-so, so-and-so. The competent authority while file number so-and-so that has furnished prosecution sanction against the aforesaid officers. Accordingly, a charge sheet is being submitted against the three alleged officers. At this stage of investigation, custodial interrogation of the alleged officers is not required.
There is no apprehension.
If that is the instruction, Malas, this case can be disposed of.
Yes. Heard Mr.
S. Bishwakarma.
S. Bishwakarma, learned counsel for the petitioner. Also heard Mr. S.
A. Chandran,
A. Chandran, learned
Public Prosecutor.
Public Prosecutor, Arunachal Pradesh. This application under section 482 of BNSS 2023 has been filed by the petitioner Shri Misa Gamlin, who is apprehending his arrest in connection with SIC Vigilance PS Itanagar case number 5/2013 under section 120B/468/471/409 of IPC, read with section 13 within bracket 1 within bracket small c within bracket small d and 13 within bracket 2 of the Prevention of Corruption Act 1988. The gist of accusation in this case is that on 27/5/2013, an FIR has been lodged against the petitioner by one RTI activist alleging that he has dishonestly misappropriated the funds sanctioned under what scheme?
The funds was, the sanction order is at page 13, Malas.
Government funds. Stop. Learned counsel for the petitioner has submitted that the petitioner has been cooperating in the investigation since 2013. However, recently the state of Arunachal Pradesh, the government of Arunachal Pradesh has issued an order dated 12th March 2025 under section 17 of the Prevention of Corruption Act 1988, whereby the Inspector of Police in Anti-Corruption Bureau under Vigilance Department have been empowered to make arrests without warrant, and therefore the petitioner is apprehending that he may be arrested in connection with this case. On the other hand, learned public prosecutor Arunachal Pradesh has produced a correspondence, produced a letter that is dated 13 July 2025 by Deputy SP cum officer in charge of Anti-Corruption Bureau Itanagar, whereby it is intimated that the investigation in this case has already been completed and there is no requirement of custodial interrogation of the accused persons, including the petitioner. In view of the above letter, it appears that there is no apprehension of getting arrested or no apprehension of the petitioner getting arrested in connection with SIC Vigilance PS Itanagar case number 5/2020 2013. Stop. As there is no apprehension, this is not a fit case for grant of anticipatory bail to the petitioner. Hence, this case is accordingly dismissed.
No, item number 6 and 7 are also similar. They are co-accused.
Same.
Same lordship.
Item number 6.
And 7 lord.
6 and 7, name of the petitioner would be different. Remaining everything will remain as it is.
Okay.
Item 4.
May it please, Lordship. 482 application, Lordship. Here, Lordship, before I place the FIR, Lordship, I would like to place para number 2, detailing, Lordship, my details, Lordship. Here, Lordship, may I read the contents, Lordship, what I have mentioned in para number 2. The petitioner most respectfully submit that he is engaged as an employee under a person which considers his principal means of livelihood. And in addition to the said occupation, the petitioner also renders assistance to Sivan Shankar Bhumi, through which he supplements his income. The petitioner earns his livelihood through the aforesaid lawful means, and the same forms the sole source of subsistence for himself and his dependent of the family member. So this petitioner, he engaged himself as an employee of one Shankar Bhumi, Lordship. Now, Lordship, the present affair, the situation was that, Lordship.
Where is the affair?
Pursuant, it starts from page 11, Lordship, first communication from the additional Director General of Police. Here referring to an email and letter, Lordship. May I read the contents of at page 11? With reference to subject cited above, I have the honor to inform you that this office had received a copy of letter under reference number so and so, wherein it has come to our attention that certain miscreants are circulating a fake letter with a forced signature of undersigned to various divisions under Water Research Department. The letter as above is fraudulent, as the signature stated in the order is claimed to be done by me, which is not true, and pertains to the ongoing issue mentioned in this office earlier corresponding under reference number 2 and above. In this regard, you are requested to look into the matter and also requesting it to register a case against the aforementioned letter, take appropriate action against the person. Moreover, at CID, inquiry number 36/24 is already registered against the contents of the said letter. So this was initiated pursuant to that CID has registered a case. Lordship, and that case has been registered as CIDPS case number 4/2025 under section 61, that is criminal conspiracy, cheating, forgery, etc., all these, Lordship. And pursuant to this affair, lodging of the affair, one Ranjan Pig was arrested, Lordship, while he was under detention, Lordship, and still he is under detention. And at that moment, he named a few persons, Lordship. So, Lordship, why my apprehension came, Lordship? Lordship, I like to refer again page 15, communication from the CID, Lordship, dated. It is 7/7, but pursuant to that, I was called in CID office on 4/7. I have mentioned that para number 7 of my petition again, Lordship. I'm reading again, para number 7 of my petition, that the petitioner must respectfully submit that owing to solely to his professional and work-related association with Sri Shankar Kumar Bhumik and also being a victim himself in the fraudulent activities allegedly perpetrated by accused Ranjan Begu, he was summoned by investigating authority on 4/7/2025 for the purpose of interrogation in connection with the present case. The petitioner appeared before the investigating agency on the said date and made truthful disclosure of all facts and information within his knowledge pertaining to the present case. The petitioner fully cooperated with the investigating agency during the course of the said investigation. This was the scenario, Lordship. Again, I was called on 7. Then again, I have again, Lordship, that I have referred page number 15. Now page number 16 again. Yesterday was also my date. So now every day, Lordship, I'm being harassed and they are threatening me that I will also be sent to jail, Lordship. This made a reasonable apprehension, Lordship. My humble.
Where is that statement?
What, Lordship?
That they will arrest you.
Is this notice is there, Lordship, and they are since several person has been sent to jail, Lordship. I being a poor person and I.
Where is that statement?
Once he appeared,
You were not arrested.
Some information is required.
Where is the apprehension?
It has been given under section 35(3) of the NFA.
They are threatening me every now and.
Where is that statement that they are threatening you?
Section 35(3), when the police officer in all cases where the arrest of the person is not required.
Lordship, para 9, I have stated that
Once he has been
petitioner moves little grammatical mistake here, that the petitioner moves respectfully be that despite his bona fide conduct, lawful character and full cooperation extended to the extent investigating agency, he is subjected to arrest solely on account of purely professional and work-related association with Kumar Bhumik, and not requesting the fact that he himself a victim of the fraudulent acts committed by principal accused, namely Ranjan Begu, and the same would amount to a gross violation of fundamental rights petitioner as guaranteed under the Constitution of India, petitioner being allowed with no criminal adherence, seeks a kind protection of this honorable court to safeguard his liberty from the arbitrary and unwarranted arrest. This is the statement I have, Lordship.
What is the basis of your apprehension that once you appeared, you were not arrested?
Further information.
Further investigation.
My,
What raised your apprehension?
because, Lordship,
What caused?
because they are threatening me, Lordship.
Where is that they are threatening you? There is no such statement in your petition.
Lordship, what I say, Lordship, I may be protected in the meantime.
No, you will be protected.
Keep on going.
First,
I'll keep on going every day.
you
Lordship.
fulfill the conditions of 482. 482 is maintainable only if there is an apprehension of getting arrested.
Notice is there, they will take me into custody, Lordship.
There is no such statement. You either bring it on record. There is no such.
Bring it on record tomorrow, Lordship. I'll bring it on record tomorrow, Lordship. Kindly, Lordship.
Section 35.
Kindly, Lordship. I'm cooperating, Lordship, very honestly. I'll bring it tomorrow, Lordship. For my mistake, my client should not suffer. I'll bring it tomorrow, Lordship.
Not tomorrow.
Day after tomorrow, Lordship. Day after tomorrow.
On Tuesday.
Lordship, day after tomorrow. It will be a motion matter, hardly will take 2 to 5 minutes.
For rejecting, it will not take much time.
Lordship, I believe, Lordship,
Miss T. Som, learned counsel for the petitioner, who prays for allowing the petitioner to file an additional affidavit to bring on record certain facts which are relevant for consideration of the instant anticipatory bail application. The prayer is allowed. Let this matter be listed
tomorrow.
Day after tomorrow. That is on 18th.
18. And keep
Item 47 from supplementary list.
May I please, Lordship? Proceed.
482 application.
Yes.
So the FIR is page 15. Lordship.
What is the offense?
Offense
NDPS.
NDPS. It is, offense mainly is the one is died while consuming some drugs at the house of the accused. CD may be required.
Yes. Heard Mr.
B. Kumar.
B.
Kumar.
B. Kumar.
Kumar.
B. Kumar, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Call for the case diary. Let this matter be listed.
Themazi, my lord, 1st of August.
On 1st of August.
Item 48.
May I please, Lordship? 482 application also. The offense Lordship 120B, 420, 12, 7, 8 of the PCI. The petitioner is a private person. So at best, section 8 of the Prevention of Corruption Act will come. Because the allegation is that he offered bribe.
You offered
Bribe. And the prime accused Lordship will find an annexure 2. He has been granted bail by the Honorable Court. So I pray I will Lordship grant me.
Annexure 2 is
Lordship. Annexure 2 is the order, the High Court's order, granting bail to the prime accused, the public servant. Initially, interim was granted, thereafter it was made absolute.
okay. Yes.
Lordship, we require 2 weeks of time to file our objection.
Let them file, in the meantime, Lordship will protect you.
Regarding interim prayer,
Yes, sir, Lordship.
no interim prayer, what is your?
Lordship,
You will not get 2 weeks for filing objection against the interim prayer in the bail application.
Lordship, then a week's time may be granted.
For interim prayer,
Dear Lordship, Lordship, we need the time to file objection.
That along with the case.
no, what is your submission? On his prayer for grant of interim bail.
Actually, my senior, she is on the way, so he has just asked me if
Bail, grant interim bail and also allow you to file objection.
if interim may not be granted.
No, main accused has been
He has been
granted. Granted. Heard, okay. Heard Mr. D. Talukdar, learned counsel for the petitioner. Also heard Miss, what is your name?
Lordship, MS.N. Chaudhary for Ms. M. Kumari, CBI.
Miss N. Chaudhary, appearing for Miss M. Kumari, learned standing counsel, CBI. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Pavan Chandra Bora, who is apprehending his arrest in connection with CBI ACB PS case number RC 0172025A002. Where is the FIR?
FIR
The,
Page 18.
the gist of accusation in this case is that on
This we have stated in para 3 of our application, page 4.
that on 18/3/2025 an FIR has been lodged before the officer in charge of CBI ACB police station, inter alia, alleging that that it has been and that an information was received through reliable sources at CBI ACB head office. That, what is your name? Okay, okay, that one, Dr. Ravindra Kumar Rawal.
He is the primary. He was the principal scientist of CSIR.
Who was working as the principal scientist at CSIR NEIST Jorhat. Obtain undue advantage. What was the accusation? You offered
I
bribe.
used to supply articles out there, substandard articles, and he used to give favor to me by taking bribe from me. That's the allegation.
Obtain undue advantage by
Offering bribe. to me.
by taking bribe from the present petitioner. Stop. Learned counsel for the, what is your submission regarding the accusation?
As per bill, they have made the payment to me. I have never offered anything.
Learned counsel for the petitioner has submitted that the accusation made against the petitioner in the FIR are not true and he is innocent. He further submits that the petitioner is ready to cooperate in the investigation. He has also submitted that in the meanwhile, the main accused, namely Shri
Ravindra
Kumar Rawal, has been granted anticipatory bail by a coordinate bench of this court in AB case number 712/2025, dated on 26/3/2025. Stop. He therefore prays for grant of anticipatory bail to the petitioner. On the other hand, learned counsel for the CBI prays for allowing the CBI to file a written objection. Stop. After considering the submissions made by learned counsel for both the sides, this court is of the view that perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary. Let this case be listed on 8th of August 2025. In the meanwhile, the CBI is also allowed to file a written objection against the prayer for bail, anticipatory bail made by the petitioner. They shall do so. They shall submit the written objection before it shall submit the written objection before the next date fixed. In the meanwhile, considering the fact that the main accused has already been granted anticipatory bail by a coordinate bench of this court, the petitioner, the above named petitioner, is directed to appear before the investigating officer of CBI ACB PS case number RC 0172025A002 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following of the conditions number 1 and 2. List accordingly.
Much. Item 9.
This scan copy you have to go through, madam, after some time or active. You have to go through this scan copy.
Let him go through.
Item 11 and 12.
Lordship, pass over for the time being on login code.
No, madam, CD with FSL report you have not received, madam. After the CD was called for with FSL report, madam.
CD has not been received.
With FSL report. Earlier CD was there, but
Okay.
it was taken back for FSL report, madam. With a commercial
Okay.
quantity, madam.
What is your name? UC?
Pankaj Boro.
K. Barua, learned counsel for the petitioner. Also Mr. K. Parashar, learned additional public prosecutor, who prays for some more time for producing the up-to-date case diary along with the FSL report. The prayer is allowed. Let this case be listed again on August 5th of August.
Item 14. Item number 14.
None has appeared for the petitioner on call. The learned Mr. K. Parashar, learned counsel for the petition, learned additional public prosecutor, prays for some more time for producing the case diary. Prayer is allowed. Let this case be listed on 11th of August.
No comment.
Item 15.
May I please your lordship? The application lordship, petitioner was arrested on 10/12/2020. Today is about 4 years, 7 months, 6 days, lordship. In this case, lordship, last occasion, direction was passed.
Yes, you want to say something?
Your lordship, my senior Mr. SCKL is on legs, so kindly pass over the matter for the time being. He will appear, your lordship.
In how many cases he will appear?
For 2 cases, your lordship.
Okay, let him come. Let him come.
Deeply obliged.
On last occasion, one direction was passed. Today, the bill shall be considered. That direction was passed there, lordship.
We will consider it.
Obliged.
Item 16.
None has appeared for the petitioner on call. On perusal of the office note, it appears that the scanned copy of the trial court record has not yet been received. Hence, issue reminder for the same. Let this matter be listed on 6th of August. Mr. B. Sharma, learned additional public prosecutor, is present for the state.
Item 17. 17, lordship, there is an office note which says that service is complete. So Amicus will be appointed.
Respondent number 2. Okay. Heard. Miss, what is your name?
Yepto.
N.
Yepto.
N. Yepto, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Miss A. N. Hussain, learned counsel appearing for respondent number 2, who prays for some time for filing written objection against the prayer for bail of the. You have filed. So we can take it up, consider it today.
Yes.
Yes. You are ready? Yes.
Your lordship, the accused petitioner has been under detention since 24/4/2025. Your lordship.
How many days?
Your lordship, 82 days as of today.
Investigation is on.
Complete, lordship. Her date of birth is 10/10/2007. So at the time of offense, she was around 17 years, lordship. And her 183 statement has been recorded, lordship, which clearly implicates the present petitioner, as has been stated in the FIR. Statement is here, lordship.
What she has stated in 183?
Almost as what has been stated in the FIR, lordship, that some nude photographs have been taken and she was assaulted.
Your lordship, as in the general information of the student, it's showing that the date of birth of the alleged victim is 31/12/2005, which will be approximately 19 years old at the time of the alleged occurrence.
The 183 statement also, she has implicated two persons, also, the present petitioner and one more person whom she doesn't recognize, Lordship. In the meantime, Lordship, her one, if Lordship kindly produce the 183 statement.
Now, what is the progress of investigation?
They are arrested, Lordship, and medical is also there, Lordship.
Now, why are you opposing?
In a heinous offense, Lordship, there is always a threat perception to the victim.
There is a possibility of influencing.
Yes, that possibility, they are nearby, Lordship.
Where is your objection, written objection? What ground you have taken on in the written objection?
Number 5.
Para number?
Fine. It's a minor lawsuit.
Okay, she's minor. Any other objection? Now, why he should not be released now? Because the investigation has progressed. It is almost complete.
In respect of that topic, the mobile handset has been seized, their mobile handset. It has been sent for FSL also, but that report has not come. And also the blood sample has been taken. In that regard also, it is awaited. That is the progress of the investigation.
Why are you objecting? No, whether you apprehend that he will threaten you after, that you have to say. Where? Why are you apprehending that he will threaten you? Okay, this is a valid ground.
Your Lordship, can we come to page 5, paragraph 6? May I read it, Your Lordship?
Para?
Para 6, page 5.
Yes.
Did you accuse?
19 years.
Okay.
What is the age of the
17 years, the birth certificate.
birth certificate is there?
Your Lordship, a copy of the general information of the student has been annexed where it stated that date of birth of the alleged victim is 13/12/2005, approximately 19 years of age at the time of the alleged occurrence. Your Lordship, the general information of the student was taken from UDSI Plus, which is Unified District Information System.
Say, assuming that she's 19, then what is your submission?
Your Lordship, in the general information of the student, she is.
Okay, let us assume that she is 19 years old. Then what would be your submission? That she is major. Still, you are the perpetrator.
The accused petitioner and the alleged victim, they were in a consensual relationship and had voluntarily attended the fair together. Your Lordship, the FIR itself indicates that they were.
May I please, Lordship, my senior is in under courtroom, kindly pass over the matter for a time being.
Otherwise, my lord, intermediate quantity, today is 41 days, we have not received the FSL. FSL is not before us.
Yes, there is there. What is the progress?
The FSL, my lord, he, in his statement, he also stated that he consumed drugs and.
How much was the quantity?
Quantity 6 grams of heroin.
6 grams.
He sent to some other person to also, my lord.
Okay, heard, mister. What is your name?
My senior is in.
What is your name?
Myself, Priyanka Putin. Yes. My senior is in under courtroom, kindly pass over the matter for a time being. My lords.
Now, this is not a case for passing over. Heard Mr. P. Bod. What is your name?
Priyanka Pratim Das.
P.P. Das, appearing on behalf of Mr. P. Bordele, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Shri Partha Pratim Hajorika, who has been detained behind the bars since 4/6/2025. Where is the FIR?
It's 13 months.
The gist of accusation in this case is that on 4/6/2025, one Rajdeep Newar had lodged an FIR before the officer in charge of Bishwanath Sarali police station, inter alia, alleging that on receipt of an information through reliable sources that large quantity of suspected heroin are being would be transported in a vehicle bearing registration number AS32B4474. Stop. Accordingly, a search team was constituted and a Naka checking was arranged. During Naka checking, the vehicle, the above mentioned vehicle was intercepted and 3 occupants were, and at the time of interception, 3 occupants were there in the vehicle. During search of the said vehicle, 6 grams of suspected heroin was recovered therefrom. Stop. What is your submission?
Lordship, the alleged contraband, Lordship, amounting to 6 grams, Lordship, not recovered from him, Lordship, which is clearly reflected from the seizure list at page 21.
From whom it was
Bedabrat Kapur.
learned counsel for the petitioner has submitted that though the petitioner was one of the occupant of the vehicle from where the contraband was recovered, however, it was not recovered from the possession of the present petitioner. He submits that the seized contraband was recovered from the possession of a co-occupant of the co-accused, namely Bedabrat Kakoti. Stop. He also submits that the petitioner has been detained behind the bars since last 42 days, and considering the period of detention, he may be allowed to go on bail. On the other hand, learned additional public prosecutor Mr. K.K. Parashar has produced the case diary of Bishwanath Sarali PS case number 109/2025 and has submitted that the investigation has fairly progressed and it is pending only for receipt of the FSL report. Stop. Considering the submissions made by learned counsel for both the sides and also considering the progress of the investigation as well as period of detention undergone by the petitioner, this court is of the view that further custodial detention of the petitioner may not be necessary if he cooperates in the investigation. Stop. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the learned special judge, learned Chief Judicial Magistrate Bishwanath Sarali, Bishwanath, with following conditions 1 and 2. send back the case diary. This bail application is accordingly disposed of.
Oblige your lordship. Item 19.
I'm sorry, my lord, CD not received.
I take the lordship. Lordship, we are not pressing the matter.
You are not pressing? Okay. What is your name?
SR Magar.
Heard Miss S.R. Majar Bhuya, learned learned counsel for the petitioner, also heard Mr. K.K. Das, K.K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner is no longer, you are withdrawing it, and the petitioner may be allowed to withdraw the instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
Item 20.
CD not received, my lord.
Hmm?
CD not received.
Already 37 days lordship behind the.
What is the offense?
Offense, my lord, wife lodged the affair, my lord, against the petitioner lordship, my lord, matrimonial discord lordship. My lord, on the occasion of Eid lordship, she wanted to go to her matrimonial home. While I was asked to, my lord, drop her, my lord. I told my lord, after Eid, I'll go. While she was greedy, my lord, some unwarranted situation was created, lordship. She, my lord, got her, my lord, forehead hit on the, my lord, wall. Then lost the affair. This happened, lordship.
Serious injury.
Then affair, lordship. Already 37 days, my lord. It is not a case, my lord, that the relation will be cut off. No.
Mr. M.H. Ahmed,
109 is there, my lord.
learned counsel for the petitioner, also Mr. K.K. Parashar, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Let this case be listed again on
Short, my lord, very
Proper,
short.
my lord, 29.
29,
Today is 37 days, lord.
29/7.
One more, lord.
If you press, I will make it after that.
No, lordship, no, lordship. Item 21, always.
The 483 application, is raised under section 10 of the.
Bishop notice not received, my lord, Amicus Curiae may be appointed, my lord, otherwise.
Yes, lordship, CD is available, so lordship may appoint an Amicus,
Heard Mr. N.K. Kolita, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has submitted, learned additional public prosecutor has submitted that the notice issued to respondent number
My lord, service, now we have informed that the service completed, so.
notice issued to respondent number 2 has been duly served. In stock. However, as no one has appeared for the respondent number 2, this court is inclined to appoint one Amicus Curiae to defend the cause of respondent number 2 in this bail application. Any other, apart from Mr. Nawaz? Okay, Mr. This court accordingly appoints Mr. S. Nawaz as Amicus Curiae to defend the cause of respondent number 2 in this case. The petitioner is directed to furnish copy of bail application along with the annexure to the newly appointed Amicus Curiae during the course of the day. When we can fix it?
Can it be on Monday, madam? Because 39 days already.
Tuesday. Let this matter, case diary is there.
Yes, yes.
Let this matter be listed again on 22nd of July. The case diary available before the court shall be retained till that day.
Oblige. Item 22.
Also, my lord, 483 application, my lord. A petition was registered on, my lord, 18 May 2025, my lord. As on today, my lord, 59 days, my lord. Allegation is section 21 B and 29 NDPS Act. My lord.
59 days.
Yes, my lord.
Twelve point 76 grams of
Suspected heroin, my lord.
net weight.
Where is the rejection order? Why special court rejected your?
No, my lord. It's a rejection of benign, my lord. No, I have not filed it before the trial court, my lord.
Why?
My lord, already I have filed this petition, my lord, listed on 26 to 25, my lord. And that on that day, my lord, case that was called for, my lord. 2 days.
No, I want to understand why instead of approaching the special court, you are rushing to the high court in intermediate quantity cases also. The trial court is empowered to grant you bail.
Sometimes, my lord, will reject the-
Sometimes you give wrong advice to your clients. What is to be done? Mr. Sharma.
Yes, because to be fair enough, let's say 58 days.
59.
59.
Heard Mr.
NK Das.
M.
NK Das, my lord.
M.K. Das, learned counsel for the petitioner.
12.76, my lord.
Net weight.
Net weight, my lord. Suspected heroin.
Other co-accused have been told lordship they've been granted bail by the.
The case diary is there.
Yes, case diary. Official report is still available.
Okay. Also, Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNS has been filed by the petitioner, namely Hirok Jyoti Deka, alias Harihar Deka, who has been detained behind the bars since 18/5/2025, within bracket for last 59 days, in connection with Bayhata Chareli PS case number 122/2025 under section 21B/29 of the NDPS Act 1985. Where is the FIR? The gist of accusation in this case is that on 18/5/2025, one Jayanto Rajkwa had lodged an FIR before the officer in charge of Bayhata Chareli police station that on that day an information was received through reliable sources that the present petitioner, in association with some other persons, would be selling suspected heroin at Muktapur Chowk in the evening hours. Stop. Accordingly, a search team was constituted and it reached the Muktapur Chowk and spotted three persons there, including out of these three, the petitioner was not there.
Petitioners, dear my lord, 3 persons, my lord, including me, my lord.
3 persons, including the petitioner. On search of the petitioner, 12.76 grams of suspected heroin was recovered from him. Stop. Learned counsel for the petitioner has submitted that. What is your submission? That the petitioner has been detained behind the bars for last 59 days. And as the contraband involved in this case is of intermediate quantity, the maximum statutory period of detention during investigation is only 60 days. Any other submission? Co-accused?
Work is already granted bail from the trial court, my lord. Last Friday, as per information.
Then why you came to this court? This is a wrong approach. Learned counsel for the petitioner has also submitted that the co-accused persons have already been granted bail by the trial court. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Bahata PS case number 122/2025 and has submitted that the investigation has fairly progressed and it is pending for receipt of FSL report only. Considering the progress made in the investigation as well as period of detention already undergone by the petitioner, he is allowed to go on bail of, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned special judge.
My lord, additional district and session judge, Romia.
Learned additional session judge Rongia with following conditions. Number 1 and 2. Send back the case diary. This bail application is accordingly disposed of.
If level.
23 Lordship, as per the office note, that was taken way back, Lordship. So, in that, no report has come up. So, may I pray, Lordship, then Amicus can get something. Already records has been received, Lordship.
This is a POXO matter.
Earlier also I had approached my lord. I had filed a anticipatory. Earlier also I had approached my lord. I had filed an anticipatory bail, my lord, regarding the same FIR, but I was arrested while the said anticipatory bail was pending, my lord. On 1/6/2025, I was arrested, my lord, and since then I have been in custody, my lord. Similarly situated persons, my lord, have already been granted bail, my lord. If my lord has page 51, my lord, Junmoti Pegu. 51 of the petition, my lord. Effective page is 55, my lord. 54 and 55, sorry.
Yes.
My humble prayer is that, my lord, since similarly situated persons have been granted.
What
bail,
is the offense?
my lord, would kindly have the FIR, my lord, at page 13, my lord. 1-3. Oh, sorry, my lord, I'll just read out the sections. My lord. Sections are, my lord, 61 to 109.
Who are you?
My lord, I am one of the accused, co-accused, one of the accused in the case.
What is your name?
My lord, my name is Vishnu Kutu.
Vishnu.
My lord, allegations are attempt to murder, unlawful assembly, voluntarily causing grievous hurt, and criminal conspiracy. Second
Yes.
round of litigation.
Yes.
My lord, earlier, my lord, that is as stated by my learned friend, that is my lord on 12/6/2025, my lord. The AB, my lord, here, my lord, the present accused petitioner was there, as because that time he was arrested, that becomes influxless. My lord was pleased to granted bail to others petitioner, except three, my lord, there, my lord, interim was negative, my lord. There is still, my lord, police searching them, my lord. Here, my lord, newly section added 103, my lord. Tonight. Because my lord, he died, my lord.
But,
PM report is
but
there.
he is behind the bars for 40.
He is behind the bar for my lord for the last 44 days, my lord. 44 days. And but his implications are there, my lord. I have fact mark all these things, my lord. And that is because of that injury, my lord, he died, my lord. Not only the informant, but the independent witnesses are there. And here only, my lord, the point is that, my lord, there is a conspiracy party is there, my lord. Because from the investigation, what has come out, that all these are they are the ardent followers of one, my lord, political party. And because of that, there is some conspiracy. And as a result of this, my lord, because of that reason, my lord.
No, now whether you require his further custody.
Because only part is conspiracy, my lord, not other part, my lord. My lord, may kindly peruse. I have flag mark as an independent witness, my lord. Because the plan was there, my lord. Kill the my lord, to restrain him or something like that. That has to be come out, my lord. And other three persons, they are also, my lord. Only.
What is your name?
My lord, Vishnu Kutum.
Vishnu Kutum. Three of the co-accused are yet to be arrested.
Those who are, my lord, vacated by this court, my lord. Earlier interim was vacated, my lord.
We have
12/6, my
again
lord.
applied an anticipatory bail application, that is item 42 of today's list, my lord. It is also there. But my lord, this is a separate thing, my lord, because my lord, last 45 days I am in custody, my lord. I don't know about the CD,
Other
my
parts,
lord,
my
but
lord,
otherwise,
is very clear, my lord.
I'll just submit that my senior friend. My lord,
Okay.
even if there is something, my lord, I am already there for 45 days.
Heard
Investigation.
Mr. P.R. Sharma, learned counsel for the petitioner. Also heard Mr. K. Bosher, learned additional public prosecutor. This application under section 483 of BNS as 2023 has been filed by the petitioner, namely Vishnu Kutum, who has been detained behind the bars since 1/6/2025 within bracket for last 44 days.
Date of arrest is 2/6/2025, my lord.
2/6/2025 since last 44 days in connection with Jonai PS case number 37/2025 under section 61 within bracket 2/189 within bracket 2/109 within /117 within bracket 2 and 103 of BNS. The gist of accusation in this case is court para number 2 from page 53. Learned counsel for the petitioner has submitted that the petitioner had earlier approached this court by filing an anticipatory bail, which was rejected by this court, and thereafter the petitioner got arrested on 1/6/2025. Stop. He submits that since the date of arrest, the petitioner.
My lord, it was not rejected. My lord, I was arrested during the pendency of the anticipatory bail application.
Okay.
Sorry, my lord.
Change karo. Learned counsel for the petitioner has submitted that the petitioner had earlier filed an application for anticipatory bail. However, during the pendency of the said bail application, the petitioner was arrested on 1/6/2025. And since the
2/6.
2025. And since then, 44 days have lapsed. Learned counsel for the petitioner has also submitted that 6 of the co-accused persons, how many have been granted bail?
My lord, 13 of them, my lord. I'll just, my lord, may kindly have page, my lord, 42 is,
How many have total?
yes, my. 13 টা আছে, না? My lord, 13, my lord.
13 co-accused persons have already been granted bail by this court. And considering the period of detention undergone by the petitioner, he prays for grant of bail to the petitioner also, as he stand on similar footing to that of those who were granted bail by this court earlier. Stop. On the other hand, learned additional public prosecutor has produced the case diary of by NDPS case numbers 37/2025 and has opposed the grant of bail to the petitioner on the ground that there are sufficient incriminating material against the petitioner in the case diary. He has further submitted that the investigation as regards the accusation of criminal conspiracy has not progressed much, and therefore custodial detention of the present petitioner
They are also not arrested, my lord. If he may be
may
released
be
by the-
required. It is further submitted that some of the co-accused are yet to be arrested in this case. Hence, if the petitioner is allowed to go on bail, it may jeopardize the investigation. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the case diary which is available before the court. It appears that on perusal of the case diary, it appears that there are some incriminating materials against the present petitioner in the case diary. However, considering the fact that 13 co-accused are already granted bail, as well as considering the period of detention already undergone by the petitioner within bracket 44 days, this court is of considered opinion that if the petitioner cooperates with the investigation, his further custodial detention may not be necessary for fair completion of the investigation of NDPS case number 37/2025. Stop. Hence, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate. No, SDGM Jonai.
SDGM Junai. SDGM Junai.
Learned SDGM Jonai. With following conditions, number 1 and 2. Send back the case diary.
Deeply obliged, my lord. Deeply obliged.
Item 25.
May I please, Lord. Lordship, I am behind the bar since 26/4/2025, and as of today, 82 days I'm languishing behind the bar, Lordship. The offense is under section 152, 196, 197, 1A, 352, 353 of the NS. The present affair is culminated from the incident where the present petitioner allegedly commented on Facebook post, which was in live Facebook post of which was in live on the Pahalgam attack, Lordship. On that live video, the petitioner commented a bad comment, Lordship, allegedly. And the police has registered this case and arrested on 26/4/2025, Lordship. Though the police have arrested the petitioner and book him under section 152 of the
Case diary is there.
Yes, Lordship.
Lordship, though the petitioner is booked under section 152, Lordship, I'm humbly submitting this section is not applicable in this case, Lordship. The comment which have been passed by this present petitioner, mainly it may create the enmity between the different groups on ground religion, Lordship. And for that, Lordship, 196 is there, Lordship, and the police has rightly inserted that section. But here another 152, Lordship, and this is the sedition charge, Lordship, really. This is the earlier in IPC it was section 124, and now it is 152, Lordship. The police has to apply reasonable care while applying 152 PNS, Lordship, because that is the sedition charge, Lordship.
Sedition is no longer an offense.
Yes, Lordship, but the section, the content in the section is
Endangering sovereignty and integrity of India.
Yes, Lordship, but
that is not equivalent to sedition.
yes, but in the section, Lordship, the contents of the section is similar to the 124 IPC, Lordship. And the only sense is, Lordship, that is the word sedition was there, but in this section, Lordship, endangering sovereignty of India, Lordship. India, Lordship, the admittedly, so Lordship, though let's assume Lordship passed bad comment, Lordship, it may create anger between between different group, Lordship. For that, Lordship, 152, Lordship, is not applicable.
Okay, that is a valid submission.
Yes, Lordship.
152.
Another submission, Lordship, I'm behind the bar since 24th.
How many days? 82 days.
82 days, Lordship.
Sufficient.
Sufficient, Lordship.
Your investigation is over.
Investigation is almost complete, Lordship. We have received the report from the Meta, Lordship, Facebook here. That account number is linked, the IP address is linked to his mobile number. That much is clear, Lordship. So he has
Now it is deleted. It is still on Facebook.
that, Lordship, is not clear, Lordship.
Lordship, my mobile have been seized, Lordship, so I could not delete it.
The comment.
Okay.
This comment is
yes, anything? Heard, Mr. What is your name?
R. Islam, Lordship.
R. Islam, learned counsel for the petitioner. Also, Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Jarib Ali, who has been detained behind the bars since 26/4/2025 within bracket for last 82 days in connection with Borpeta PS case number 153/2025 under section 152/196/197 within bracket 1 within bracket small a /353/352 of BNS read with section 66 of the Information Technology Act. The gist of accusation in this case is that on 25/4/2025, the one Chinmay Hajorika, SI of Police of Borpeta Police Station, had lodged an FIR before the officer in charge of Borpeta Police Station that on that day an information was received from Cyberdome's social media center that a Facebook post, that in the Facebook account, namely Sharif Singh, had commented a live post commented in the live post against the Hindu religion. And during preliminary inquiry, it was found that the said Facebook account belongs to the present petitioner. Stop. Learned counsel for the petitioner submits that the heading of section 152 of BNS, no, learned counsel for the petitioner submits that from bare perusal of the FIR, it appears that the comment in the post which was uploaded in Facebook was made against a religion, and therefore heading of section 193 in this case, 196 in this case was appropriate, but it does not attract the provisions of section 152 of PNSS, as the act of posting a comment against a particular religion may not be regarded as an act endangering the sovereignty, unity, and integrity of India. Stop. Learned counsel for the petitioner has also submitted that the petitioner has already been detained behind the bars for last 82 days, and considering the period of detention, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Perpeta PS case number 153/2025 and has submitted that the investigation has fairly progressed, and in the course of investigation there are sufficient materials were found to indicate the complicity of the present petitioner in the offence alleged in the FIR. He, however, submits that the investigation is almost complete. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the case diary. Stop. As the investigation is almost complete, and as the petitioner has been detained behind the bars for last 89 days, 82 days, considering the above aspects, this court is inclined to grant bail to him, as if he cooperates in the investigation, his further custodial detention may not be necessary for completion of investigation, for fair completion of investigation of the aforesaid case. Stop. In view of the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the learned Chief Judicial Magistrate Barpeta, with following conditions. Number 1 and 2. Send back the case diary. This bail application is accordingly disclosed.
56.
Yes.
Please, Your Lordship. Regular bail petition, my lord, has gone to the 55 days, my lord. And section is 21B, 25 and 29 of NDPS. And it is called for, my lord, and you can look at, my lord.
Intermediate quantity, Lordship,
10.69 grams has been recovered, allegedly recovered from me, my lord.
The FSL report has not been issued as of yet.
And as of today, 55 days, my lord. I'm not a fan because later on, my lord, I was arrested, my lord. I'm just on that I was arrested in Sotia police station.
Why you were arrested?
My lord, I was picked up from my home, my lord. And after I was arrested, but so far the arrest memo is concerned, my lord, it is shown that I was arrested in Sotia police station, my lord. It is alleged that from my car, suspected heroin substance has been recovered, which is of 10.69 grams with container, my lord. And that is available in, my lord, in the
What is the weight of the Mr. Sharma?
at page number 18, my lord.
Yes.
I'll have a look, my lord. It is a 47 BNL's notice, my lord. Ground namely of arrest, it is written, my lord. Open interception and search. Found 8 numbers of small plastic container containing suspected to be heroin wrapped with a black color polythene kept concealed beneath the mat of vehicle.
No, without container, what is the weight? Before the inventory, before the magistrate.
With container 60.56 grams. On this whole.
With container?
Reduction 60 point. In this, I have to verify something, my lord. In this case, my 3% has been arrested, my lord. I am not an FIR named accused, and 2% was arrested and FIR was lost. From that 2%, there is some recovery, my lord. And later on, I was picked up from my home, my lord. And from my possession, my lord, is alleged that heroin substance was recovered, which is of 10.69 grams with container. As a whole, maybe if they calculated both, my lord, then maybe it is 60, my lord. But from my position, as per the 47 BNNS notice, my lord, it is 10.69 grams with container.
Okay.
I was arrested, my lord, 3 days after the closing of the FIR and the arrest of the other persons. My lord.
Inventory is there or not?
Inventory is there, Lordship. Actually, 2 seizures are there, Lordship. That's why the
My lord,
confusion.
there are 2 seizures, my lord.
What is your submission?
Lordship, only it is pending for FSL reports also.
In today's
Lordship, all the 3 accused persons were arrested in, they were acting together, Lordship. They all have been arrested, Lordship.
Okay, heard.
MAI.
Mr. M.A.I. Hussain, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNS has been filed by the petitioner, namely Noor Jamal Haq, who has been detained behind the bars since 23/5/2025 within bracket for last 55 days in connection with Sutia PS case number 54/2025 under section 21 within bracket small b /25/29 of the NDPS Act. The gist of accusation in this case is that on 25/2025, one Trilochan Das. No, one Trilochan Das, SI of police, had lodged an FIR before the officer in charge of Sutia police station, inter alia, alleging that on that day an information was received regarding transportation of drugs in a vehicle bearing registration number AS 12CC1410 near Sutia. Stop. Accordingly, a search team was constituted and a Naka checking was organized at Patia Gaon Tiniali near railway crossing. Stop. During Naka checking, the aforesaid vehicle was intercepted and 3 persons were apprehended from the said vehicle within bracket tempo. On search of the said vehicle, Twenty numbers of plastic containers were found in the pocket of one of the occupant of the vehicle, namely Jamir Ali. The weight of the contraband found was 27.08 grams. Whereas regarding further search, another 33.48 grams of suspected heroin was found. The learned counsel for the petitioner has submitted that the petitioner was not there at the time of the search of the vehicle from which the contraband was recovered. Stop. He submits that petitioner was later on arrested from his residence with an accusation that this tempo is yours.
No. On 23, I was picked up, my lord, and thereafter my one car was seized, which was is in the name of my brother, my lord. From that car, it is alleged that the 10.69 grams suspected heroin was found, my lord. And the car number has been mentioned in the 47 variance notice, my lord. There is a different car, my
lord. Last line. House with accusation that 10.69 grams of heroin was recovered from the vehicle bearing registration number AS12AG 0659. This vehicle is yours.
In the name of my brother, my lord.
Which is registered in the name of the brother of the petitioner. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars for last 55 days, and considering that the accusation against the petitioner is regarding possessing intermediate quantity of contraband for which maximum statutory period of detention is 60 days, he may be allowed to go on bail. On the other hand, an additional public prosecutor has produced the case diary of Sutia PS case number 54/2025 and has submitted that the investigation has fairly progressed and is pending only for the receipt of the FSL report. Stop. I have considered the submissions made by learned counsel for both the sides. Considering the progress made in the investigation, as well as period of detention undergone by the petitioner, this court is of considered opinion that if the petitioner cooperates in the investigation, his further custodial detention may not be necessary for fair completion of the investigation of Suthia PS case number 54/2025. Accordingly, the above named petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of learned special judge Bishwanath Sarali. Learned special judge Bishwanath Sarali. Send back the case diary. This bail application is accordingly disposed of.
27. Yes, CD has not been received.
My lord, the issue is very tiny, my lord, and perhaps in my respectful submission, CD may not be required because of the fact that the material that has been, that is the allegation against me, that has been reflected in the trial court orders, my lord, and the forwarding report. My lord, actually, I am not an FIR name accused. Two FIR name accused were some Khetri, their names are there in the FIR. The mother and the son, Tapos Chetri and Khorgeswari Chetri. The FIR is at page 12, my lord. Their house was searched and many materials were seized therefrom, including drugs and stolen materials. And I was arrested on the basis of the statement made by a co-accused. Now, my lord, what is the allegation against me? I am a salesman in a pharmacy. Since last 40 years, I am working there. And the forwarding report at page 14, last paragraph, my lord, if your lordship can see. Page 14 is the forwarding report, my lord. Has your lordship got it?
Yes.
The accused person named Shri Pradeep Kumar Pal, 55 years, son of so-and-so, PS so-and-so, Assamese pharmacy salesman of Matri Medical Hall near Bongaigaon Cinema Hall, and the earlier arrested accused person Tapan Shetty has stated that he bought those syringes from this person without prescription. Well, an injection is a medical device. It is not a drug. It is not included in the list of drugs. It is a medical device. So for that, perhaps prescription is not required. Next, my lord, the Honorable District Judge, while rejecting my bail prayer at page 16.
Only syringe.
Only I am a salesman, my lord.
Oh.
Kindly see the last page of.
Why the trial court rejected your bail?
My lord, that is recorded, my lord. At page, my lord, 16, last paragraph.
Yes.
As regards accused Pradeep Kumar Pal, only allegation is that he has sold syringes to the accused persons. However, selling of syringes without prescription is prohibited, and even if syringes are sold without prescription, there should be a limit. CD reveals that there has been regular purchase of syringes from the accused, Shri Pradeep Kumar Pal, by the other accused. This is the allegation. I am a diabetic.
Since when you are behind the bars?
From 22 June, my lord. Well, in my respect,
how many days?
25 days. Today is 25 days.
NDPS.
Well, if lordship can see Drug and Cosmetic Act, my lord.
Yes, what is there?
In Drug and Cosmetic Act, section 3, subsection Roman 4, such devices intended for internal or external use in the diagnosis, treatment, in mitigation or prevention of diseases or disorder in human beings or animals, as may be specified from time to time by the central government by notification in the official gazette after consultation with the board. And this list is at the footnote, my lord. The central government has specified by order dated 6th October 2005 the following devices intended for external or internal use in human beings or drugs with immediate effect, namely cardiac stent, drug-eluting stents, catheters, intraocular lenses, IV cannula, bone cements, heart valves, scalp vein set, orthopedic implants, internal prosthetic replacement. These devices are included in the list of drugs, not the syringe, my lord. Therefore, NDPS Act, Section 2122 does not come in my case. my lord.
Yes. And 29 is not there.
29 is not there, my lord, so far my knowledge is concerned, because FIR does not say anything.
Yes, Mr. Sharma.
Your allegation is regarding Lordship syringe, but if Lordship kindly comes to page 14, just for a moment, Lordship, the forwarding. The other co-accused, Lordship, point number 3, the arrested accused person, Rajan Thakur alias Tuntun. He was earlier arrested, Lordship, so he was a habitual offender. Now, Lordship will kindly come to the next page. Also, the arrested accused persons, namely Rajan alias Tuntun, also stated that earlier he used to bring this syringe from this person, Pradeep Kumar.
No, but syringe, can it be covered under NDPS?
Drug, the book doesn't say so.
NDPS, Lordship, that is a different issue, whether it is covered or not, Lordship, but there has to be some prescription, as has been noticed by the.
No, it is unfounded. Where is the where is the law that says that syringe has to be sold under prescription? That is unfounded. That is why I am before a superior court.
Only that is the allegation, Lordship, apparently, Lordship, on the face of it.
Heard Mr. A. Samuel, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that the case diary is not available and seeks some more time for producing the case diary. On the other hand, learned counsel for the petitioner submits that in the instant case, the petitioner has been arrested merely for selling syringe without prescription, and this act is neither an offense nor covered under any of the provision of NDPS Act. Stop. The gist of accusation in this case is that on 19/6/2025, one Bhaskar Bora had lodged an FIR before the officer in charge of Bongaigaon Police Station, interiorly alleging that on that day, an information was received through reliable sources that one Tapas Chetri and his mother are indulging in selling and selling in prohibited drugs to unknown persons. Accordingly, a search team was constituted and the residence of Tapas Chaudhary was Tapas Chetri was searched. Stop. During search operation, where is the seizure list?
My lord, seizure is mentioned itself in the page, next page, my lord. What they have seized is mentioned in the next page.
During the search operation, some empty plastic containers, insulin series, and
Well, there are many materials they have.
9 numbers of SPM PRX capsules suspected to be psychotropic substance, and some other articles were recovered from the house of the said Tapas Chetri. Heroin was also recovered.
Yes, yes. It was 6.64 grams.
it is also alleged that 6.64 grams of heroin was also recovered during the search operation. Learned counsel for the petitioner has submitted that the petitioner has not been named in the FIR and he is a salesman at working in Matri Medical Hall near Bongaigaon Cinema, near New Bongaigaon Cinema Hall. And the accusation against him is that the main accused Tapas Chetri bought some syringe, bought these syringe which were recovered during such operation from the present petitioner without prescription. Learned counsel for the petitioner submits that no narcotic drug or psychotropic substance was seized or was recovered from the possession of the present petitioner, and syringe is not included within the purview of NDPS Act 1985. He also submits, while learned counsel for the petitioner, while referring to the provisions of Drugs and Cosmetic Act 1940, submits that as per Section 3 of the said Act, certain for selling.
Section 3, subsection Roman small, Roman 4. The injection syringe is not treated as drugs. Injection syringe is a medical device, but not included in this list of drugs. Some medical devices are included in the list of drugs, my lord. That has been referred to in
Section 3,
subsection Roman 4.
in Section 3, subsection Roman 4.
B, section 3, subsection B, small b, my lord, subsection small b, then subclause Roman 4.
No, how it is relevant? It is not relevant.
Because syringe is a medical device, my lord. And if it is a medical device, some devices are included in as a drugs.
Some devices are included as drugs.
But
where it is?
It is in this book, my lord. If lordship can read, drug includes so and so, so and so, so and so.
Where? Okay.
But syringe is not included. Therefore, though it is a medical device, it is not included in it.
He also submits that even under Drugs and Cosmetic Acts, which provides for inclusion of certain devices, medical devices within the definition of drugs under Section 3,
subsection B,
within bracket small b, within bracket small Roman 4. However, said list of devices which may be regarded as drug does not include syringe, which is otherwise a medical device.
No.
Stop.
Absolutely. Correct.
Stop. What is your submission?
The Deputy Commissioner is empowered to limit the sale of syringe without prescription. In other states also that has
No,
been
but that is not the case.
That is not the case. Here, Lordship, he has been selling syringes and supplying to Lordship habitual offender involving drugs.
Okay. Learned counsel for the petitioner submits that though it appears that the syringe is not included within the definition of narcotic substance, narcotic drugs or psychotropic substance in the NDPS Act 1985. However, in the instant case, the petitioner was facilitating the use of narcotic drugs by the co-accused persons by selling the syringe without any prohibition. He further submits that Deputy Commissioner of a district can limit the sale of syringe to a specific number
Without prescription.
without prescription. Stop. I have considered the submissions made by learned counsel for both the sides. Apparently, it appears that there is no accusation against the petitioner having possessing, selling, or possessing, selling, purchase, import, transportation, imports, import, etc. of any narcotic substance or narcotic drugs or psychotropic substance. The allegation, the instant case has been registered under section 21B/22A of the NDPS Act. Even there is no accusation of abatement or criminal conspiracy against the present petitioner in this case. As the syringe which is recovered from the as the syringe which the petitioner is accused of selling to the other co-accused without prescription does not come within the purview of narcotic drugs and psychotropic substance, further custodial detention of the petitioner in this case is not justified. Accordingly, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount subject to the satisfaction of learned Special Judge Bongaigaon with following conditions, number 1 and number 2. This application is accordingly this bail application is accordingly disposed of.
I'm obliged.
Finding item 15.
Lordship. Rectification application, Lordship. Petitioner was arrested on 10/12/2020. Today is about 4 years, 7 months, 6 days. And in this case, final complaint submitted on 5/6/2021 and charge frame on 30/11/2024. And in the final complaint, 10 numbers of witnesses cited. And out of 10, only 4 witnesses examined till today, Lordship.
Earlier your prayer was rejected.
Rejected, my lord.
When?
Earlier rejected on Lordship 11/4/2025.
Where is the rejection order?
Lordship will find the rejection order at page number 71. This petitioner earlier Lordship got an interim order from the trial court, and then Lordship he got the bail. After that he again surrendered before the trial court, Lordship. Interim bail, Lordship will find at page number 55. relevant portion will be at page number 56. As his mother expired,
Why earlier the bail was rejected?
mother rejected on the ground that it's because of section 37 laws. Paragraph number 12 at page number 74.
No, it was rejected on
On
11/4.
11/4.
Now what is the change within these 3 months?
In these 3 months, only one witness examined, my lord. And my lord, co-accused got bail from dishonorable court, lordship. Lordship will find at page number
Where is the
55. No, sorry. 58.
no? Why your bail was rejected? On what ground?
Only considering the 37, my lord, but that is lordship we
No,
have.
whether prolonged incarceration was considered.
That is not considered, lordship, in my petition. In paragraph 12, lordship. Because of in the page number 75, lordship will last the first line. Commercial quantity and as such the embargo and embargo under section 37 of NDPS Act will definitely come into play here in this case. Moreover, from the material
And why the co-accused was granted bail?
co-accused granted bail, lordship,
By the same court.
same by the same court.
What was the logic?
Lordship, it is all the K. Najib, Mohammed Salman, Hanif Sheikh, and all this discussed here in this case, lordship. And in the almost about 4 years in paragraph number 9, it is mentioned in that order, and only 2 witnesses examined by the trial court. And he is the owner of the truck.
Okay, he stands in different footing.
Lordship. And in this case, lordship, kindly peruse the page number 56. It starts from page number 55. Kindly see the conduct of the present petitioner, lordship. In regards to my position, lordship, it is cleared by the trial court. Lordship, my mother expired and I filed a petition before the trial court, lordship. Interim order granted in favor of the accused on lordship 12/5/2023 with a direction to appear before the court on 9/6/2023. Accordingly, after getting the bail, I after completion of this interim order, lordship, I surrender before the court, lordship, on 9/6/2023. So I was inside the jail from the date of arrest, except those 1 month, lordship. I still inside the jail, lordship. And my incarceration about 4 years, 6 months, 6 days, lordship. 6 months about it will explain. So, my lord, in this case, in so many cases, your lordship also considered that long incarceration is there, lordship. Article 21 will come into play in this case, lordship. Because out of 10, in last order also it is reflected, lordship, by the honorable court, lordship.
Yes, where?
Last occasion, it is reflected that today bail shall be considered.
No, that all bail will be considered. Some will be allowed, some will be rejected. Without consider.
Inside the jail for about 4 years, 6 months inside, but they could not
Yes,
come.
mistake.
Lordship, co-accused bail granted because nothing was recovered from him, Lordship. Here, contravent was recovered from the petitioner, Lordship. And Lordship, here, Lordship, page number 71 is the Lordship order passed by the order passed on 11/4/25. Well, bail rejected on merit, Lordship, because contravent was recovered from him. That is why bail rejected, Lordship. In page number, Lordship.
Whether in this order, question of long incarceration was considered, not considered.
Lordship, here, court directed, Lordship, page number 75. This court is not inclined to grant bail to the petitioner. However, trial court is directed to take initiative to complete the trial within 4 months.
Within 4 months already.
In 4 months, Lordship, 2 witnesses have been examined, Lordship.
Out of 10.
Out of 9, Lordship.
Or so within 3 months, only 2 additional, 1 month is remaining.
4 dates were fixed for evidence, Lordship. 2 days, Lordship, witnesses.
Yesterday also case fixed, my lord, no witnesses appeared. Kindly consider a
No, I am only considering that when you approached this court in the month of April, have you not pressed for long incarceration?
Yes, Lordship.
Then that was not considered.
That line, Lordship.
But that was not considered.
That was not reflected in.
Not reflected.
Not reflected, not considered. It should.
Yes, what is your submission regarding long incarceration? 4 years is too long a time.
Trial has been delayed because Lordship case was fixed for appearance till 2023. Because one of the accused person was.
Maybe he is not at fault.
So Lordship, till now, Lordship.
Heard Mr. S. Heard Miss S. Is learned counsel for the petitioner. Also heard Miss M. Deka, learned counsel appearing for NCB. This application for bail under section 483 of BNSS has been filed by the petitioner Jalman Singh, who has been detained behind the bars since 10/12/2020. This within bracket for more than 4 years, 6 months in connection with special NDPS case number 23/2021 under section 21C/29 of the NDPS Act, corresponding to NCB crime number 16/2020. Where is the final complaint?
Final complaint, Lordship, will find at page number 27.
The gist of the accusation in this case is, in brief, is that on 5/6/2021, the NCB has filed a complaint before the learned Special Judge Kamrup Amingao against 4 accused persons, including the present petitioner, inter alia, alleging that on 9/12/2020, an information was received by the NCB that 2 persons, including the present petitioner, will be transporting huge number of fentanyl codeine based cough syrup in a vehicle bearing registration number PB 13 AW-9785. Accordingly, a search team was constituted and the aforementioned truck was intercepted. During search of the said, you are the driver?
I was the co-driver.
During
Jora Singh is the main driver also.
During search of the said truck, total 19984 bottles of cough syrups, codeine based cough syrup were recovered from their stop. Learned counsel for the petitioner has submitted that the petitioner was arrested on the from the said truck, as he was the co-driver of the said truck, and thereafter trial begins. Stop. On 30/11/2024, charges were framed against the present petitioner and other co-accused under section 21C/29 of the NDPS Act. Charges were framed under 21 or 22?
No, 30/11/2024.
Under what provision charges were?
Charge claim 21.
21
C.
C/29 of the NDPS Act. Learned counsel for the petitioner has submitted that she has approached this court mainly on the ground of mainly seeking bail on the ground of prolonged incarceration. She submits that the petitioner has been languishing behind the bars for more than 4 years, 6 months, and out of 10 listed prosecution witnesses, only 4 witnesses have been examined. Stop. Learned counsel for the petitioner has further submitted that the petitioner, before moving the instant bail application, had approached this court for seeking bail on earlier occasion, and by order dated 11/4/2025, passed in bail application number 3876/2024. A coordinate bench of this court had rejected his prayer for bail and directed the trial court to complete the trial within 4 months of the said order. She submits that more than 3 months have been lapsed since the date of that rejection. However, only 2 more witnesses have been examined till date, and it is unlikely that the trial would culminate soon. She further submits that though the petitioner on earlier occasion also had pressed for bail on the ground of prolonged incarceration, however, said aspect has not been considered by the coordinate bench while rejecting the bail application of the petitioner. She further, which case you are relying? You are relying? She further submits that there are judgments of apex court.
Lordship order would like to proceed.
Give one. Judgments of apex court, which indicates that prolonged incarceration overrides the embargo of Section 37 of the NDPS Act. So, we'll continue at 2 from this point. अपनी আহিব লাগিব at 2.
One more judgment is there, Lordship.
Yes, last. দুইজন কাউন্সিলর সাবমিশন রেকর্ড করা হয়েছে only petition. I'll dictate it in chamber part. 1 lakh with 2 sureties of like amount. Bail is allowed with certain conditions. The chamber of law.
Item fixed at 2, item 46.
May it please your lordship. Lordship, this is a regular bail application, lordship, and 30 days in jail custody, lordship.
How many days?
30 days, 30, lordship. Already this case is registered under lordship 61-2 and 318-4 and 36-3 and 342 of BMS. Lordship, forgery, lordship. And this petitioner, lordship, FIR lordship will find on page 14, lordship. This petitioner is a PT contractor, lordship. He has a no working, getting some contract work from this water research department, lordship. Allegation is that, lordship, no specific allegation against this petitioner, but the FIR, lordship, that will find on page 14, lordship. May I read that, lordship? Absolutely based on documentary evidence, lordship. Now 30 days forwarding report, lordship, say only 3 days custody was shot by the police, lordship. During in jail custody, lordship, she has not been interrogated by the police, lordship. May I read the lordship with a reference to
What is the accusation?
Accusation is, lordship, forgery of the document, lordship. Not
What documents?
Lordship, service, that lordship is in the 2017, lordship, what happened, lordship? One writ petition was filed, lordship. Those petitioner, lordship, seeking appointment on reappointment on a fake document, lordship. Now, lordship, that in that regard, lordship, now, lordship, this FIR was lost, lordship. That is stated, lordship, no specific allegation against this petitioner, lordship. But some fake document has been later with a forced signature of this informant, lordship, regarding, lordship, appointment, fake appointment, lordship. That is the allegation, lordship. On that basis, lordship, this petitioner was arrested, lordship. Page 19 is the forwarding report, lordship, and ground of arrest, that is on page 20, lordship. Page 20, paragraph 2, lordship.
What letter you have faked?
Lordship, that I have not faked anything, lordship. I have not, that is no specific allegation against me, lordship. But ground number 2, lordship, is say ground of arrest. From the statement of the witness, it is unearthed that sum of money was taken by her following a deal for master role job under water works department. Lordship, no, I have no access to the department, lordship, only getting the lordship contract work, lordship.
Nothing beyond that, lordship, nothing is is against me, lordship. And then, lordship, during investigation, lordship, the police shot for 3 days police custody, lordship. So gravity of the offense, lordship, in this case, lordship, on that lordship, 10th lordship, my bail was rejected by the court below, lordship. I filed in lordship additional affidavit, lordship, annexing that bail order, lordship. That was with the record, lordship. Since, lordship, this allegation based on documented evidence, lordship, considering the length of detention, lordship, that petitioner can be allowed on go on bail, lordship, any stringent condition, lordship, she will ready to cooperate with the investigation, lordship.
The seal and signature of the chief engineer, water resource department were forged. And that letter was fake.
Posed by whom?
It was produced to given appointment to some masteral worker, and this petitioner took money from those masteral workers as per the statement of the witnesses.
Okay.
And in considering the bail, my lord, we have to go by the statement of the witness at the preliminary stage, my lord. So at this stage, CD is required, my lord.
It is not there.
No, it is motion, my lord.
Oh.
Lordship, CD is lying in the High Court, lordship. Today, one item is fixed in court number.
Case diary would be required.
Case diary is lying with the court number 19, lordship. Today is fixed on the 13 and 14 item.
When can you produce the case diary?
And some item is fixed tomorrow also before this court also, lordship. Item number 14.
Produce the case diary tomorrow. Tomorrow produce the case diary.
If it is there, I don't know, my lord. I have not maintained it. As because motion matter, my lord, we have not.
Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Perusal of the case diary would be necessary. Learned counsel for the petitioner submits that case diary has already been called for in connection with some other case.
That is, lordship, AB number 1567 of the 2025.
Namely, AB number
1567 of the 25.
25. Enough.
Another 1576 of the 25.
The learned additional public prosecutor is requested to verify the same. If the case diary is available, same shall be produced before this court tomorrow. Let this matter be listed again tomorrow for case diary.
Because today that other lordship co-accused bail is listed before the court 19 lordship, item number 12 and 13 lordship. That they have taken an adjournment, lordship. It is fixed tomorrow, lordship.
Okay, if CD is available, we'll consider.
Yes, lordship. Considering the length of detention, lordship.
Unless we will, otherwise we'll again give date for case diary.
Yes.
If it is available, okay.
Obliged.
Fine.
May it please, lordship, I have been in custody for 1003 days, lordship. It was 2 years, 9 months till today. And out of 8 witnesses, 4 witnesses have been examined. Then
What is date of your arrest?
date of 17th of October 2022.
Yes, what is yours?
Yeah, then lordship, and the long incarceration, other than long incarceration, one more grounds of arrest, which is not mentioned in the certified copy of the section 50 notices. And
Where is that notice? Section 15 notice you have annexed?
yes, no, I have given the certificate. Earlier it was not annexed.
You have taken that ground in your application.
No, lordship. Definitely. Now I am taking.
Yes.
Firstly, I want to state your lordship, the charge was framed on 26/4/2023. Then 4 PWs were already examined, lordship. That the dates were 17/7/23, 31/7/23, 14/8/23, 20/11/2023. all are on a regular basis, Lordship. However, 1 year has gone because the other two co-accused has absconded, Lordship. They were on bail, then they, without any steps, they remain absent, Lordship. So NBW issued from 19/3/2025, 2024, on 22/2/2024, these persons were not come to the court, Lordship. Until date, they are not coming to the court.
So trial is not progressing.
That is because of these two other persons, Lordship, co-accused. So if he is also be released on bail, the same fate may be there, Lordship.
Till when you will detain him?
No, other two persons, Lordship.
Till you arrest the other two person, you will keep him behind the bars.
No, Lordship, I am not on that, Lordship.
Then
But still, why it is incarceration is more, Lordship. That is the graph.
no, but whether he is at fault,
It's not
the
there.
present petitioner is not at fault.
Lordship.
And 2 years.
9
What is the contraband? How much is the contraband
765 grams, 765 grams
of?
heroin.
It is also not a less quantity.
Yes,
Heard Mr. M. Khan,
Rahman.
M. Rahman, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. This bail application under section 483 of BNSS has been filed by the petitioner, namely
Colin Simpson.
Kup Colin Singson, who has been detained behind the bars since 1711, 17, what is the 1710, 2022, within bracket for more than 2 years, 9 months, 4 months,
2 years, 9 months.
more than 2 years, 9 months, in connection with NDPS case number 1/2023 under section 21C/29 of the NDPS Act 1985, pending before the Court of Learned Special Judge Kamrup, Amingaon. The gist of accusation in this case is that on on 17/10/2022, one Tanmoy Nath had lodged an FIR before the officer in charge of North Guwahati Police Station, inter alia, alleging that an information was received through reliable sources that a group of drug peddlers were coming from Manipur carrying some narcotic substance in a white color Bolero vehicle bearing registration number ML05M0748. Stop. Accordingly, a Naka checking was arranged at
NH 31.
At National Highway number 31 near the checkpost. And during the Naka checking, the aforesaid vehicle was intercepted. And on search of the vehicle, 3 occupants were found in the said vehicle. Stop. During search of the vehicle, 765 grams of suspected heroin was recovered from the said vehicle. Learned counsel for the petitioner has submitted that the petitioner has approached this court seeking bail mainly on the ground that he has been languishing behind the bars for last more than 2 years, 9 months. However, till date, only 8 out of only 4 out of 8 listed prosecution witnesses have been examined. And now the trial is not progressing. He further submits that there is unlikelihood of trial culminating at the earliest, and therefore, considering the prolonged incarceration of the petitioner, he may be allowed to go on bail. Learned counsel for the petitioner has also submitted that though no specific plea is there in the bail application, however, the petitioner was also not furnished with the written grounds of arrest at the time of his arrest on 20/10/2022. He submits that notice under section 50 of the CRPC, which was served on the petitioner at the time of his arrest, does not contain any grounds of arrest. It only mentions the PS case number as well as penal provisions involved in the offense. He therefore submits that the fundamental rights of the petitioner guaranteed under Article 21 as well as 22 within bracket 1 of the Constitution of India has been violated in this case, and on that count he is entitled to get bail. You are relying on some judgment?
Yes, Lord. Please. Viraj reply, Viraju Ram Ravi Prakash here. Should I provide you question?
Yes.
My submission in concise, shall I submit the?
Yes, yes. If you have prepared it, then submit. On the other hand, learned additional public prosecutor has opposed the grant of bail to the petitioner on the ground that contraband seized in this case is of commercial quantity, and therefore the embargo of Section 37 of the NDPS Act is applicable to this case. He further submits that the delay in trial is not due to any fault of prosecution side. He submits that 2 of the co-accused who were earlier granted bail in this case have jumped the bail, and their attendance could not be procured during trial, and therefore trial is halted. He submits that if the petitioner is also granted bail, there is a likelihood that he would also jump the bail, and therefore he vehemently opposed the grant of bail to the present petitioner. I have considered the submissions made by learned counsel for both the sides and have gone through the materials available before this court, including the scanned copy of the records of NDPS case number 1/2022. When the charges were framed?
It was framed on 26th April 2023.
It appears that charges were framed in the trial before the trial court against the petitioner on 26 April 2023. However, till date, only 4 out of 8 listed prosecution witness have been examined. It also appears that presently trial is not proceeding as 2 of the co-accused have jumped bail. Stop. Though prosecution may not be at fault for delay in the trial in the instant case, however, the present petitioner is also not at fault for the said delay, and he is languishing behind the bars without there being any progress in the trial. The apex court has observed in the case of Ravi Prakash versus State of Orissa, reported in 2023 SCC Online SC 1109, that prolonged incarceration generally militates against the most precious fundamental right guaranteed under Article 21 of the Constitution of India. And in such a situation, the conditional liberty must override the statutory embargo created under Section 37 within bracket 1 within bracket small b of the small b within bracket Roman 2 of NDPS Act. Apart from the aforesaid judgment, in many other cases, the apex court has observed that long incarceration is violative of fundamental rights guaranteed under Article 21 of the Constitution of India. And if the court comes to a conclusion that in a particular case, the incarceration is long enough, it can come to a conclusion that the fundamental rights of the petitioner guaranteed under Article 21 is violated. And on that count, it overrides the embargo of Section 37 of the NDPS Act. In the instant case also, the petitioner has been detained behind the bars for more than 2 years, 9 months. However, the trial is not progressing and only 4 out of 8 prosecution witnesses have been examined. Stop. This court is therefore of the considered opinion that the petitioner is entitled to get bail in the instant case on the ground of prolonged incarceration. Stop. As regards non-furnishing of grounds of arrest to the petitioner at the time of his arrest, it also is a good ground for grant of bail to the petitioner. However, this court does not wish to discuss it in detail as the petitioner has already been found entitled to get bail on the ground of prolonged incarceration. Stop. In view of above, the above named petitioner is allowed to go on bail of rupees. Above named petitioner is allowed to go on bail of rupees 1 lakh with 2 sureties of like amount, subject to the satisfaction of learned. Whose satisfaction? Learned Session Judge, Learned Special Judge Kamrup, with following conditions, NDPS conditions. This bail application is accordingly disposed of.
Highly opposed.
Wait, please, Your Lordship. The accused was arrested on 10/3/2024, Your Lordship. Today, 10 March 2024. Today completed 1 year, 4 months, and the 6 days, Your Lordship. And the articles are recovered 2015 gram, not kg, grams of morphine. And Your Lordship, the accused person is the local person, Your Lordship, and I have annexed him here, Your Lordship. Page number 29 is of his certificates. Page number 29.
No, on what ground you are seeking bail?
Yes, Your Lordship. The charge has been framed on 12/12/2024, Your Lordship. Since that day, no any witness has been come, Your Lordship.
So
Yes, Lordship. I have a
37 is there.
not 37, Lordship, because Your Lordship, here I have a.
No, you're on what ground? You are seeking bail on the ground of long incarceration
Yeah.
or any other ground?
Yes, Lordship. The BA number 2917.
You answer my question, Miss Medley. On what ground you are seeking bail?
Yeah, I have a
Long incarceration.
long incarceration, and here I have a one ground, Your Lordship. On the paragraph number 9. Paragraph 9, number 9 of my petition of the page number 6. Accused person was arrested on 10/3/2024 and FSL report has been submitted on 28/11/2024. Means after arresting that 295 days, we have received the FSL report, Your Lordship.
Yes. Then
180 days is the statutory period, Your Lordship. And here I have a division bench judgment also, Your Lordship. Without the FSL report, which the charge sheet has been submitted, it is invalid, Your Lordship. I have annexed in here.
this I'm not clear. You are seeking bail. You are not seeking default bail. This is pending trial. Trial is now going on.
Yes. Charge sheet submitted after, Your Lordship, after FSL report submitted on after arrested of the accused, 295 days completed. When he has completed 295 days in custody, on that time FSL has been received. Without the FSL report, which the charge sheet submitted, this is the invalid charge sheet.
You have not challenged the charge sheet.
Lordship, I have submitted the division bench of judgment, Your Lordship, in this case. On the page number 30, Annex R8.
No, if it is invalid charge sheet, you have not challenged the charge sheet.
Yes, Lordship, I have filed the bail petition before the Honorable Trial Court, but Trial Court.
If you are challenging the charge sheet, there has to be a separate proceeding. Now you are facing trial.
Yes, Lordship, I am facing trial.
Though you are detained behind the bars for 1 year, 4 months.
Yes.
But I am of the view that any period less than 1 year, 6 months for NDPS cases where the quantity of contraband is of commercial quantity cannot. It depends on case to case. How much contraband is recovered in this case?
1,015 grams.
So it is not a small.
Lordship,
You will not get benefit of prolonged incarceration unless you complete 1 year, 6 months.
the Supreme Court of Judgment, Your Lordship, Ravi Prakash versus the state of Odisha.
How much?
Out of 19, only one witness has been cross-examined.
But in that case, what was the period of detention? Yes.
Yeah, I have another case also, Your Lordship. Hussein Ahmed Khan, DA number 3487.
You can wait for 2 months. Or you convince this court that you have a ground.
Lordship, kindly, I may be allowed to submit the another order set, Your Lordship, 3487/23. In this case also, Your Lordship, 1 year, 3 months, he has granted bail, Your Lordship.
How much was the contraband?
Paragraph number 3, Your Lordship. Mr. Biswas learned counsel lying on the decision of the Honorable Court in the Muhammad Muslim versus State, repeated in AIR 2023 S6 164 contains that there is no scope of early disposal of trial and the petitioner is under incarceration for more than 1.5 years.
One and a half years means 1 year, 6 months, not 1 year, 3 months.
The accused person is student, Your Lordship, and he is the local person.
No, you are making wrong submissions. Yes, Mr. Kyal. You have options because if it is less than 1 year, 6 months, I may not allow.
Pending this case, Your Lordship, no allow for another date.
For what purpose? You have to.
Waiting, Your Lordship. I am searching some of the another.
You may.
Order copy where is allow the bail before the 1.5 years.
Okay, let her produce.
It's fine.
Miss A. Medhi, learned counsel for the petitioner. Also had Mr. S.C. Kyal, learned additional public prosecutor, learned standing counsel DRI. Learned counsel for the petitioner has submitted that the petitioner is mainly seeking bail on the ground of prolonged incarceration, as he has been detained, he has been languishing behind the bars for last more than 1 year, 4 months. More than 1 year, 4 months. On a specific query posed by this court, whether this period may be considered as long enough to get the benefit of bail on the ground of long incarceration, learned counsel for the petitioner prays for some time to produce some more authorities in that light, in that regard, where even for lesser period, the benefit of bail was granted on the ground of prolonged incarceration. The prayer is allowed. Let this matter be listed after 2 weeks.
Much of
Item 23.
Lordship, here, I've taken the instruction, Lordship, regarding service of notice. I have been informed that they have sent the notice, Lordship, of service through post to the registry. So probably it has not been received. So if Lordship kindly fixes it on Monday, maybe meantime it will be received by the registry.
Who have sent? Police?
Yes, Lord.
But whether it has been served?
Yes, it has been served and they have served.
No, we don't require notice. Your submission is enough. If you have been informed by IOC that it has been served,
it has been served, Lord.
Then we'll appoint an amicus. Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that he has been telephonically informed by the officer of the jurisdictional police station, officer in charge of the jurisdictional police station, that notice sent to the respondent number 2 has been duly served. Stop. No one has appeared on behalf of respondent number 2, hence, this court intends to appoint one amicus curiae to defend the cause of respondent number 2 in this case. Any amicus is present in the court. The learned counsel. You suggest, Mr. Sharma?
Dikshit Gogoi.
Dikshit Gogoi. This court therefore appoints Mr. Dikshit Gogoi as amicus curiae to defend the cause of respondent number 2 in this case. The petitioner is directed to furnish the copy of bail application along with the annexures to the newly appointed Amicus Curiae within 2 days from the date of this order. The courtmaster shall inform the learned Amicus Curiae regarding his appointment in this case. The registry is also directed to reflect the name of Amicus Curiae Mr. Dikshit Gogoi in the cause list henceforth. List this matter again when?
23rd month.
On 23rd of July.
Item 29. Yes, Your Lordship. I have an interim matter case that has not been received.
He has not been received.
Heard Mr. D. Bora, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Let this case be listed again on 4th of August. The interim order shall continue till next day.
Deeply obeyed.
Item 30.
May I please, Your Lordship? Okay, 42 bail application. Section 6 POCSO is there, Lordship. Lordship, FIR is page number 10, Lordship. Lordship, in this case.
Consider your bail application.
Petitioner apprehension if he is appear before the land court below, trial court below, he may be taken in custody, Lordship.
Why?
So there is a POCSO matter may not be considered, Lordship. That's why petitioner apprehension that he may.
No, where is the embargo?
Lordship,
You can prefer anticipatory bail if the trial court is prevented by some
that may be.
law or something.
There
But there is no such bar. The trial court is a court of special judge, which can consider and even grant you bail if it finds it appropriate. You appear before the trial court. Whether trial court has issued summons or only summons.
Someone issued also. And next day is for appearance, Lordship.
When?
And 12/8.
No warrant has been issued.
No, because last occasion the petitioner has taken a step, Lordship. Because that.
You appear before the trial court.
Lordship, Mayor statement. Coordinator of this honorable court granted bail for charge sheet was petitioner was shown in subsequent in charge sheet, Lordship. And she page 39, Lordship. Similar seated person in petition also in POCSO matter.
No, you satisfy me.
Yeah.
If you can satisfy me, I will grant you bail. I have put some query. You still hope to make submission which can satisfy this court. I can give you time, but it is unlikely that you will get a relief under 482 under such circumstances in this court.
Lordship, the trial is already complete. Petitioner already shown a responder, Lordship. Generally, he may be taken in custody, Lordship. And there is a law of case between the charge sheet also. There is no sexual intercourse mentioned, Lordship.
32.
Here, my lord, CD not received, my lord, item number 32. Interim is there, my lord. Interim.
Because in this case, I am for the.
POCSO matter.
I have appealed. The forgery matter. Lord, in every case number 1127-2027, in that case, CD is there, Lord, and it was fixed today before the honorable court.
No, today we are dealing with AB case number 1098.
But that was which is referring that is listed in another court, and the CD was with that.
Of this case.
Yes, madam.
Same
Same
police station. Okay.
The 3 is there, madam. 1 is listed in another court, and CD was with that case, madam.
Then you can produce this case diary if it is in High Court.
That case was adjourned, my lord, and an order was passed to be taken on these cases.
When?
That date was not given.
Today that order was passed.
Today, sir.
Now what is to be done?
To tomorrow, my lord, because CD is available.
CD is no, but if that court has passed an order giving specific date,
The date was not given, only adjournment.
no, you don't know the order. You
I
are,
I was there, my lord.
then what was the order?
The case was list accordingly. Last order was list accordingly because.
Okay, then we will list it. Not tomorrow. Tomorrow there will be reference. On Tuesday. Heard Mr.
Yes, my lord.
S. Hawk. In both the cases you are there.
I mean, item 32.
And item number 33. Same case.
Same PS.
Item number Munmun. Item number 33, 32, 33, 34. Separate order hobo. Separate order. Lawyers on naam bele ke likhibo. In item number 33, S. Hawk.
No, my lord. 32 S Hawk.
32
S Hawk.
32 S. Hawk. 33 H. Chaudhary. And 34 D. Bora. And also had Mr. K. Bushalan, additional public prosecutor, as well as Mr. S. Sahu, appearing for the informant. It is submitted at bar that the case diary of the which police station case? Nalbari PS case number 115/2025 was called for in connection with another anticipatory bail application, namely, namely AB case number 1172, which was fixed before a coordinate bench of this court today. Mr. S. Sahu, learned counsel for the informant, has submitted that in the said case, it has been ordered by the coordinate bench of this court to tag all the 4 cases together. However, no next date of listing has been given in that case. Considering the submissions made by learned counsel, let this case be also tagged with AB case number 1172/2025 and be listed on 23rd of July.
July. Yes.
1127.
1172, no, 1127.
Well, the interim will continue.
The interim order, in all cases, interims,
Yes.
the interim order shall continue till next day.
Well, okay.
Item 38.
May I please go last? In this case, also, allegations are under section 21 and 4 of POCSO laws. FIR is at page 11.
21 of
39 and 50 are same.
39 and
50 load, supplementary load.
who is counsel for 50? You are appearing for both the cases. Okay.
For the application, Lord, so Lord, will find a FIR at page 18, Lord. Page number 18, that is the FIR, Lord. As per the FIR, Lord, so there are 17 numbers of the accused person, Lord.
17?
17 name accused, Lord. Actually, the present petitioners all were arrested, Lord, and thereafter, Lord, they were released on regular bail, Lord, by the trial court, Lord.
Thereafter?
Thereafter released on bail, Lord, regular bail. Except the present petitioners, all were arrested.
Oh, except the present petitioner.
From the FIR itself, Lord, so kindly have a look at the last paragraph, Lord, of the FIR. Adverse allegation is serious, Lordship. Otherwise, but Lordship,
What is the allegation?
Allegation, Lordship,
under section Wildlife Protection Act, Lordship, and the Arms Act, Lordship. As well as the 61, subsection 2 of the BNS. Lordship, kindly have a look at the last paragraph, Lordship. In view of the seriousness of the matter and the need to protect endangered wildlife, I request that a case be registered under appropriate sections of Wildlife Protection Act and the Arms Act, and that a comprehensive investigation be initiated to identify apprehend and prosecute the culprits involved in this organized poaching and trafficking network, Lordship. Meaning there was offer I have understood, Lordship. The name of the present petitioner as the others, Lordship, have been mentioned in the offer, Lordship, or merely on suspicion, Lordship.
What is your name?
My name is Lordship.
It is in the 567. In the FI.
Yes, sir.
Anos Najari.
It is
Yes, sir.
15, item number 50.
No, we are taking up item number.
That's
30.
six Lordship. Samuel.
39, Lordship, it is 5, Anos Najari. Then 7, Sujit Basumotari.
Item 50. And this one is Samuel.
Samuel, 6. Yes.
Yes.
Their name has been mentioned in the offer, Lordship. As per the
Okay, if there are materials in the case diary,
Lordship.
you will not get bail. Otherwise, you will get bail.
Lordship.
Now,
They are the local people, Lordship. And this is the, as per, it is the second information, Lordship. But one accused incident, Lordship. That is, Lordship, is taken from the order, Lordship, passed by the trial court, Lordship. If you Lordship permits, Lordship, I have the copy of that order.
what do you want to say?
Lordship, as per the order, Lordship, available on case study, Lordship. Lordship, I have a look at Lordship.
What is this?
Two other co-accused approached before the session court, Lordship. So just learn it. So and
Seeking anticipatory bail.
bail, Lordship.
Okay.
Enlarged on bail, Lordship. Anticipatory bail.
No, there. Facts and circumstances may be different.
Extent different, Lordship, but there are another case, Lordship. There is a Amguri PS case number 9, Lordship, for the same incident, Lordship.
There are several cases pending against you.
No, in that case, I have not this accused, Lordship.
Yes, Mr. Das.
Yes, as if you look clearly, Lordship, in the FIR, it has been seen that one of the name is Jyotin Narjari, who is named as accused number 13, Lordship. And in his lead to the recovery of elephant carcass and bones in that on 19/5/2025. Again, there are other persons are also there. One in the FIR itself it is stated, Lordship. One SMBL firearm is found in another accused person's possession. So what I want to state here, Lordship, two of the witnesses are there who have stated this person's name, present petitioner's name, not all of the three petitioner's name. That is
What they have stated?
they have stated that they are engaged in such kind of activities, Lordship, and moreover, all the persons' names who were there, Lordship, and some of them, among them, Lordship, these persons are also there who have recovered these things from whom recovered these things, Lordship, this SML firearm and this Jyotin Narjari, these persons' names are also there.
So investigation is going on. Another person is there, the other accused person's name is one is Tarzan, but I have not found his statement, Lordship. It would be more clear if his statements are also there, but still two witnesses has named him. If Lordship want to look into the statement, we look into it.
Lordship, that of,
Among some of them have been apprehended.
that's a recovery was Lordship in connection with another case, Lordship. That is the case number 9 of 2025, Lordship.
That same Wildlife Act, Lordship. As this is a
Not in
organized
connection with
crime.
the present case, Lordship.
This
It
is a
was recovered
wildlife.
in connection with the Amguri case number 9 of 2025, Lordship.
Since my friend has going into that case, Lordship, I want to state here that in that case, these persons also named that these persons, many persons are engaged.
So then,
No, কেসটা চলি থাকতে investigation to ইহতৰ shown arrest কৰিলে এইটো কৰিছে. Shown arrest has been made. Last few lines, their names are there.
What is your name? Enas.
Enas
Najari.
Lordship.
And
Samuel, Lordship. And
Sujit
Basumata.
Their names are there, Lordship. Two witnesses, Lordship, are there, stating the same thing. I flag my Lordship.
it may not be a good case for anticipatory bail.
Recovery was Lordship in not in connection with present case, Lordship. I am seeking the bail in connection with the Amguri case number, Lordship, 10 of 2025. And as per the offer, Lordship, the recovery is made in connection with the Amguri case number 9 of 2025. And in the 10 of 2025, Lordship, that is the Amguri case number, nothing is recovered, Lordship, from anyone, Lordship. We are ready to cooperate with the investigation, Lordship. There are local people, Lordship, having school going children even, Lordship.
No, but the witnesses have named you specifically in 9 of 2025.
Lordship, we are seeking bail in 10 and not for 9.
Okay.
That is a submitting, Lordship. Nothing is recovered.
No,
It is 10.
10
of the-
10. This is in regard to 10, Amguri 10.
Yes.
The statement.
No, but in statement, they have mentioned about 9 only.
Yes, yes, Lordship. I'm seeking in 10, Lordship, 10 of the Amguri, 2025, Lordship. From the offer itself, Lordship.
If you look into the 9, it is also stated that in the 9, Lordship, these persons have stated. This involved, Lordship, may I, in the FIR, Lordship.
No, but for that, in all cases, they cannot be apprehended.
It's true, but Lordship, here one line is there in the FIR. He also indicated that there are other elephants which have been poached in the Manas National Park. This is Manas National Park, Lordship. It is clearly stated. It is clearly stated in the FIR itself, Lordship. In the second para, last line, Lordship. Though it may be 9, but clearly stated, he also indicated, Lordship.
Some matters
In
may be
that
there,
case, Lordship.
So for that 9, Amguri
Because
9
this
is
is an
not
organized crime, Lordship.
Tarzan and Prosen
Yes, yes.
have been granted anticipatory bail in 10 or 9.
10.
Heard Mr.
BK Gogoi, Lordship.
B.K. Gogoi, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioners, namely Anos Narjari and Sujit Basumatari, who are apprehending their arrest in connection with Amguri PS case number 10/2025 under section 61 within bracket 2/325 of BNS, read with section 51 within bracket 1 of the Wildlife Protection Act 1972, read with section 25 within bracket 1A/27/35 of the Arms Act 1959. The gist of accusation in this case is that on 25/2025, one Pankaj Dole, SI of police of Amguri PS, had lodged an FIR before the officer in charge of Amguri police station, inter alia, alleging that on receipt of an information through credible sources that the FIR, that the accused persons named in the FIR within bracket 13 numbers of accused persons, bracket close, including the present petitioners, are involved in organized poaching activities within the Manas National Park. With help, it is alleged that the poachers remain inside the park and have hunted elephants by using SBML firearms. It is also alleged that in that respect, one Jogen nursery led to the recovery of poached elephant carcass and bones in Mainaguri and MWINAGURI region of Amteka range on 19/5/2025. So, learned counsel for the petitioner has submitted that the present petitioners are not involved in the offense alleged in the FIR, and they have been named only on the basis of suspicion, as their name appears in an earlier FIR on the basis of which Amguri police station case number 9/2025 was registered. He submits that no recovery of any wildlife material or firearm has been made from the present petitioners. He further submits that two of the named accused, namely Prosein Basumatari and Tarzan Basumatari, have already been granted bail by the trial court, anticipatory bail by the trial court. Your prayer was rejected.
No.
You have not approached.
This is the first
Okay. And considering the last time. Trial court. Stop. Learned counsel for the petitioner submits that the petitioners are ready to cooperate in the investigation and therefore prays for allowing them to go on anticipatory bail. On the other hand, an additional public prosecutor has produced the case diary of Amguri PS case number 10/2025 and has submitted that on the basis of statement of one of the co-accused, namely Jotain Nazari, Elephant Carcass, and SBML firearms have been recovered. He further submits that two of the witnesses whose statements are recorded by the investigating officer have named the present petitioners of having been involved in wildlife offenses. He submits that the investigation is still going on, and considering the fact that the offense involved are offenses under Protection of Wildlife Act, Wildlife Protection Act. What is the act?
Wildlife Protection Act.
1972. He opposed the grant of anticipatory bail to the petitioners. I have considered the submissions made by learned counsel for both the sides. On perusal of the case diary, it appears that at the present stage, nothing has been recovered from the possession of the present petitioners, though two witnesses have specifically named the petitioners of having been involved in offenses of elephant hunting in connection with Amguri PS case number 9/2025. However, in respect of the present case, that is Amguri PS case number 10/2025, apart from strong suspicion, at this stage, no concrete materials are available in the case diary against the petitioners. Under such circumstances, if this court is of considered opinion that if the petitioners cooperate in the investigation, their custodial interrogation may not be necessary for fair completion of the investigation of Amguri PS case number 10/2025. Stop. In view of above, no, stop. More so, as two of the co-accused situated similarly have already been granted bail by the trial court, anticipatory bail by the trial court. Stop. In view of above, the above named petitioners are directed to appear before the investigating officer of Amguri PS case numbers 10 of 2025 within 10 days from the date of this order and cooperate in the investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with above noted case, they shall be allowed to go on bail of rupees 30,000 each, with rupees 50,000 each, with one surety of like amount, subject to the satisfaction of the arresting authority, with following condition. Number 1, number 2. And number 3, Udibo, the petitioners shall not leave the jurisdiction of the Court of Learned Chief Judicial Magistrate, Syringe, Kajalgaon, during the pendency of the investigation, without prior leave of the said court. This anticipatory bail application is accordingly disposed of. Send back the case diary. Second matter, same petitioner नाम बेलेग बाकी एक था क्यों?
Deeply obliged, Lords.
Item 41.
May I please, Lord? My lord, here in this case, I am seeking transit anticipatory bail, my lord. As because the offence has been committed at Bengaluru, my lord. My lord, 15 days time may be given. I will appear before the, my lord, investigation agency, my lord. Yes, because I am a Betelnath businessman, my lord. My lord, notice is at page number 16, my lord, 16.
Why you cannot appear before the Bangalore court?
My lord, there is apprehension, my lord. Maybe, my lord, they may arrest it. So
No.
I may be.
Why you cannot seek anticipatory bail before the Bangalore court having jurisdiction?
My lord, I will definitely say 14 days time may be given. By this time, I
No,
will.
no, that is not my question.
My lord.
My question is, you have filed an anticipatory bail before this court.
My lord.
Though the offence was committed within the jurisdiction of Bangalore court.
My lord.
Why you did not file anticipatory bail application before Bangalore court or before High Court of Karnataka?
My lord. My lord,
That-
I am almost illiterate person, my lord. How can I approach there, my lord? I have.
That reason has to be there in transit bail application. Whether have you mentioned that reason? What is the leading case?
My lord. Priya Induria versus my lord.
Induria,
Priya Induria.
in Priya Induria case, the requirement of an application for anticipatory bail has been mentioned. What a bail application, transit bail application should consist of.
My lord, kindly page number, my lord.
Have you mentioned those things?
My lord, I have cited on judgment, my lord. Omita Garg and 6 other versus my lord. Estate of UP, my lord. My lord, page number 20.
You have Priya Indoria's judgment with you.
My lord. My lord, here in this case, my lord. One judgment referred Rajan Gogoi versus State of Assam, my lord. There are 25, my lord.
No, my query is that transit bail can be granted. This court has jurisdiction to grant transit bail. But to seek transit bail, you have to satisfy this court that why you could not appear before the court having jurisdiction. That statement has to be there in your application.
My lord, my residence is here. My lord, offense is committed at Bengaluru.
Yes, therefore you are seeking transit bail.
Therefore, I am seeking, my lord.
But why you cannot go to the court having jurisdiction? That statement is requirement. If yes, we will pass order. Transit bail will not be granted merely for asking, merely by filing an anticipatory bail. You have to comply with the conditions which are required to be fulfilled and which has been laid down in Priya Indoria's case.
Well, shall I take this matter on day after tomorrow? I will.
Yes, you satisfy this. If something is required, you add that.
My lord.
And go through Priya Indoria.
My lord.
And make me also understand about that case.
My lord. But a law judgment, just I am thinking, my lord, fairly submitting just half an hour. I got the judgment just half an hour ago. My lord.
No, transit bail application, how a transit bail application has to be filed. Priya Indoria
My lord.
gives guideline. You follow the
My
guideline.
lord, I will go.
That was my query, whether the
Day-
guidelines have been followed or
Day
not.
after tomorrow, I will satisfy.
Okay. Heard Mr. A. Paramanik, learned counsel for the petitioner. Also heard Mr. K. Bashir, learned additional public prosecutor. On a specific query posed by this court as to whether the guidelines of the apex court issued in the case of Priya Indoria versus State of Karnataka, reported in 2024 4 SCC 749, has been complied while filing this instant anticipatory bail application, learned counsel for the petitioner has sought some time to properly address this court on the said query. The prayer is allowed. Let this case be listed again on Monday, 21. You have to satisfy that the guidelines are followed and transit bail may be granted
My lord, I will file additional affidavit also.
if required.
If required.
Learned counsel for the petitioner also seek leave of this court for filing an additional affidavit if he finds same to be necessary. Leave is granted.
Item 42. My lord, this is the rising of the same FIR, my lord. That's my lord disposed of earlier on 24, my lord. But this time it is anticipatory bail application. Earlier, my lord, that is my lord, that is the Junai case, my lord, where that is
My lord, may I submit, my lord? My lord, similarly situated persons have already been granted bail, my lord. This is our second round of litigation, my lord.
Your earlier bail application was dismissed.
Was rejected. If my lord would kindly have the earlier rejection order, my lord. At page 44 it starts, my lord. And my lord would kindly have page 49 for a moment, my lord. I would just like to draw the attention of this honorable court to one vital fact, my lord. In my previous round of litigation also, my lord, three of these anticipatory bail applicants, they were granted the privilege of interim bail on 26th of May. Para 5, my lord, page 49. Learned counsel for the petitioner has submitted that in the meanwhile, by order dated so and so, the petitioners Vikas Pegu, Dharna Tarak Pegu, and Rosna Pegu, they were allowed to go on interim bail with certain conditions, and in compliance of the same, they had appeared before the investigation officer. Para 6. We had cooperated with the investigation previously also, my lord. Thereafter, my lord, this honorable court had rejected our anticipatory bail application. But my lord, my humble submission is that, my lord, we want to appear, my lord.
No,
Now,
no.
my lord,
I cannot review my judgment unless there is a new ground.
then
If the earlier anticipatory bail application, what is the new ground for?
my lord, similarly situated persons, although they were behind the bars, my lord, but they were given the privilege of bail, my lord.
That is a different question, different circumstance.
Yes.
Your bail application and interim bail was rejected after perusal of the case diary, after filing sufficient materials in the case diary, after finding sufficient material.
Yes.
Now, what is your submission? Why you have approached this court?
That is my plea right now, my lord, that similar persons have been granted bail, my lord. That is my subsequent development. Whereas, my lord, some time may be given to me. I will try to satisfy the honor of that.
CD is there.
My lord, CD is available because earlier, my lord, that was passed in the BA, my lord. Here only, my lord, my submission is that, my lord. Well, my lord, earlier, my lord, not all are rejected, my lord. My lord, the interim granted to the petitioner number 17, Rasna Pegu, is made hereby absolute with the conditions number so and so, so and so. Remaining instead, whereas the interim bail granted to the petitioner number 16, Jorna Tarak Pegu, and petitioner number 10, Vikas Pegu, are hereby vacated, and their prayer for anticipatory bail is rejected. So my lord.
So these two stand on a different footing.
My lord, that is my submission, my lord, because my lord, in this petition, my lord, that is the,
Six are there.
my lord, petitioner number 1 and petitioner number, my lord, that is 6. They were, my lord, granted interim, and thereafter their, my lord, prayer was rejected, my lord. Anticipatory bail was rejected.
And others?
Others was not rejected.
Others, my lord.
Others were not rejected, my
13
lord.
of them have been
Petitioner number
granted.
2, petitioner number 3, petitioner number 4, and petitioner number 5. But my lord,
Against the materials.
against all them materials are there, my lord. Now it is a case of, my lord, that is 103. Because died, my lord. And at this stage, my lord, that is, my lord, whenever, my lord, going through the, my lord, city, my lord, have come to know, my lord, that is these people are, the police is searching, my lord. And because it is a political murder, my lord, because these things are there, my lord. So anticipatory bail, my lord, my submission is not at this stage, my lord.
Hello, there is a FIR.
Custodial
We have also
interrogation is
preferred one
required, my
FIR,
lord, in these cases, my lord.
But
No,
kindly
no.
look page
As
30.
regards Vikas Pegu and Jharna Tarak,
Yes,
they are on a different footing.
perhaps, my lord.
If against other accused persons, materials are there, then this is not a fit case for anticipatory bail in case of a murder. Or if materials are not there, you will get bail.
Sometime may be given to me then.
Okay. Heard Mr. P.R. Sharma, learned counsel for the petitioner, who prays for some time, who prays for some accommodation before he makes his submission in this case. On the other hand, learned additional public prosecutor has produced the case diary which was called for in this case. When? August. The prayer is allowed. Let this matter be listed on 8th of
Will not be in Guwahati, my lord.
10th,
Yes, my lord. Yes.
11th.
Yes, yes.
Then 3 to 6 and back, my lord. Updated 6, my lord.
11th of August.
10th August.
10th is Sunday.
My lord, 13th August.
13th of August. Let the case diary be sent back and to be called again after updation.
I'm deeply
Item
aware.
43.
Yes.
Please, Lordship. The incident happened in my resort. I was the owner.
This is a POXO matter, my lord. Item 43, this is a POXO matter, my lord. There is service is awaited, my lord. Let us allow us some time, my lord. In the meantime, my lord, we will take information whether notice is served or not, my lord.
Heard Mr. S. Count. When?
At any date, my lord, tomorrow or day after tomorrow, at any date we can take.
Okay. Heard Mr. S. Count, learned counsel for the petitioner. Also heard Mr. K. Bushra, learned additional public prosecutor, who submits that some time may be granted to the prosecution side so that an inquiry may be made regarding service of notice on respondent number 2 from the officer in charge of jurisdictional police station, and let this court know about the fate of the same. Stop, prayer is allowed. Let this case be listed again on Friday. Friday is?
My lord, 18th, my lord.
18th.
18th.
See, my manager was arrested and he was granted bail. And they print out copy.
No, let the service be complete first. You are owner.
Owner.
My lord, in the meanwhile, my lord, CD may be called for, my lord.
Let also the case, then we will fix it in the next week.
My.
Let also the case diary be called for. Let this case be listed again on 25th of July.
Item 44. May please your opinion. My lord, this matter relates to one person. He is my lord grade 4 employee of Nalbari District Commissioner Office, my lord.
In this
He has
matter, my
been
lord,
working here, my lord, since 2008. Now here, my lord, some allegations are made against some person by the Chief Engineer of Water Resource Department of Procedural, where his
Yeah,
signature,
case diary is there,
my lord, case diary not available, my lord.
this is for the third time, lordship,
but case diary was called for.
call for, my lord, without interim. Because no notice was issued as required under section 35 of the BNSS. On that count, at least your lordship may issue at least interim so that he can appear before the IO and his case will be improved, my lord. Everything will be, my lord.
What is the accusation?
Accusation is his signature at page 13. The signature of the chief engineer was, my lord, forged and some call letters, my lord, appointment letters were issued.
Today is case of similar, same police station came. Bhaskar Jati Borra, I remember it.
Yes, my lord.
Do you remember, Mr. Parashar?
On the
Yes, my lord, yes.
What was the result?
For CID,
CID 4 of
four applications, just
25.
tomorrow,
Fixed tomorrow.
tomorrow.
Saksun.
One item is fixed tomorrow because of that.
Because we have dealt with a case today itself.
Another two case,
Case diary is pending
my lord, they have stated that case there is
in some other.
One Banikanto Medhi is there, my lord, with interim, the same case diary, my lord. AB number 1460/2025. Because of this, my lord, non-issuance of this notice, interim was granted.
It's only 46, I think.
26 Saksun.
What is it, 5,000? Yes, my lord, in the name of, yes,
Tomorrow.
yes, fix tomorrow, yes, I remember.
We will fix it tomorrow.
That
With the same case.
lady has taken money.
For master roll.
Master roll.
Several persons are there.
Heard Mr. R. Goswami, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that another bail application arising out of same police station case is fixed tomorrow. That is BA.
BA 2206/25.
BA 2206/2025, where case diary has also been called for. He prays for listing this matter along with this said case. The prayer is allowed. List this case along with BA case number
BA 2206/2025.
2206/2020. Tomorrow.
Whether this, because earlier on 26/06, 26th of June, it was called for.
Earlier petitioner, the petitioner stated that 2 AB is fixed tomorrow along with the CD. So that AB number is mentioned in the order of that case.
What is the AV number?
AB 1567/25 and 1576/25.
Fix it tomorrow. Along with these two AB.
It is tagged with that case.
That case, BA always tagged with that case.
Oblige. Item 45.
May I please, your lordship? Lordship 482 BNSS application.
My lord, here also, my lord, we have not received CD, my lord. My lord, investigating agency take some time, my lord. It is the same. my lord.
Lordship, with due permission of this, for lordship, I am not an interim, your lordship. So if your lordship kindly give me some time, your lordship, so that I can place my case, your lordship, because I'm not an interim, your lordship.
What is your case?
Your lordship, at page number 11. Typing copy. It is a brief, lordship, it is a long, FIR, your lordship.
What is the gist of accusation?
The cases that your lordship, one Creta vehicle has been used to stole a cattle, your lordship. And when the cattle, the vehicle has been intercepted by the concerned police station, there is a public deterrence restraint, your lordship, by the accused person to deter, to do their act, your lordship. So this is the case, your lordship, and the has been registered under section, your lordship, 3032, 132, 35 of the BNS, rated section 13(1) of the Assam Capital Preservation Act, and 11(1)A, 11(1)D of the Preservation of Cruelty to Animal Act, your lordship. Otherwise, if your lordship kindly produce the FIR, your lordship, that is at 11, your lordship, my name has never been whispered, your lordship. It was my allegation, my involvement in this case is that, your lordship, my vehicle has been used, your lordship, in this case. I am the owner of that Creta, your lordship, which has been used for this alleged incident, your lordship. And your lordship.
And what is your submission? It
Yes,
is used without your consent. You don't know.
No, your lordship, I have taken my vehicle on rent to the accused number 2. Out of trust, your lordship, the accused number 2 is the usual process, your lordship. The accused number 2 frequently use my vehicle, your lordship. And he asked my vehicle for marriage purpose only, your lordship.
Accused number 2, Imradul.
Yes, your lordship. I have a good relation with him.
Okay.
So for that reason, your lordship, I have given my vehicle, your lordship.
Why are you apprehending your arrest?
Because my vehicle has been used and my vehicle has been detained in the police station, your lordship. For that reason, your lordship, I have been apprehended, your lordship. Otherwise, your lordship, this is a fit case to your lordship, which can be registered in the section 3032 and 132(3), your lordship. Because your lordship, if your lordship kindly see 13(1) of the Assam Cattle Preservation Act, your lordship, it's a case, your lordship, someone have to contravene 4, 5, 6, and 7 of the CD Act, your lordship. But in my case, your lordship, that provision has never been contravened, your lordship, because FI doesn't speaks about that, your lordship, regarding slaughtering of cattle, your lordship. And if it is so, your lordship, my case, the maximum punishment of my case is 3 years and 2 years. And that will be a fit case, your lordship. A police personnel can issue 41 a notice, 35 of the corresponding section 35 of the lordship, BNS, your lordship.
Okay, heard Ms. G. Bora.
Here only my submission is that, my lord, here, that is the, my lord, what is annex is there, that is the, he is the owner. But regarding that part, it was hired by some people, my lord. That was not there. No agreement is there, my lord.
Her submission is. Her submission is there.
Yes, my submission is.
My lord, that is there, my lord. That is mentioned in the, my lord, here, my lord.
Bail application also.
Yes.
Heard Ms. G. Bora, learned counsel for the petitioner. Also heard Mr. K. Bushra, learned additional public prosecutor, who submits that though the case diary was called for, however, the investigating officer has informed him that same could not be sent due to some.
My lord, because my lord, he is, my lord, his duty, in duty, that is somehow was not able to send, my lord.
What is the reason?
My lord, he was engaged in some law and order duty, my lord.
As he has been engaged in some law, no, not necessary. He has been engaged in law and order duty. On the other hand, learned counsel for the petitioner submits that the petitioner is the owner of the vehicle which has been seized in connection with this case, and he is in no way involved in the offense alleged in the FIR. She therefore submits that as the petitioner is not having any interim protection neither any notice under section 35(3) of BNSS has been issued to him, he may be allowed to go on interim bail till arrival of the case diary. Stop. The gist of accusation in this case is that on 3/6/2025, one, who is the informant?
One SI, your lordship.
One SI of police. What is the name?
Pranam, lordship.
One. One FIR has been lodged by before the officer in charge of Ojai police station, inter alia, alleging that the accused persons named in the FIR were found using one Creta vehicle bearing registration number AS 02 Z1501 2Z1501. The number I'm again koyaso AS 02 Z1501 for transportation of cattle, for illegal transportation of cattle. And in that regard, two persons, namely Haizuddin alias Hafizuddin alias Faizuddin Ahmad and Imradul Islam were arrested. Learned counsel for the petitioner, you have produced the RC. Learned counsel for the petitioner has
17 and 18, your lordship.
submitted that the petitioner is the registered owner of the vehicle which has been seized in this case. And to substantiate her submissions, she has produced the photocopy of the registration certificate of the said vehicle. Stop. It is further submitted by learned counsel for the petitioner that the petitioner has hired his vehicle to the accused number 2 named in the FIR, namely Imradul Islam, and he was unaware of as to how the vehicle which has been hired by the accused number 2 was used. She submits that the petitioner was not aware that his vehicle was used for commission of an offense. She further submits that the provisions of section under the provisions contained under section which 11, which is not applicable.
13(1), your lordship, of Assam Cattle Preservation Act, your lordship.
13 is not there. Or
Yes, your lordship.
no, 13(1) of Assam Cattle Preservation Act is not applicable against the present petitioner, as there is no accusation against him regarding contraventions of in section
456.
456
Of the SEED Act.
4, 5, 6, 7, and 8 of the said Act. She submits that the petitioner is ready to cooperate in the investigation. However, as production of the case diary may take some time, he is apprehensive that during this period he may be arrested. Stop. Considering the submissions made by learned counsel for both the sides, issue reminder for the case diary. Let the case diary be produced when? August 13. 13 August. Or let it be after 13 August, police will be busy again in law and order.
Yes, yes, my lord, and after 15, my lord, then it will be, my lord, 20th of August,
22nd
22nd of August.
22nd August. However, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, the above named petitioner is directed to appear before the investigating officer of Hojai PS case number 177/2025 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. Thus so, within the stipulated period of time, in the event of his arrest in connection with the above noted case, he shall be allowed to go on bail of rupees 30,000 with interim bail of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority with following conditions. Number 1, number 2, list accordingly.
Item 49.
My pleasure.
Yes.
Earlier, CD was called for you.
CD is there.
CD receipt, my lord.
Also in there, your lordship, FIR is page number 9, your lordship. I read the FIR.
Yes.
Humble submission is that my minor daughter, namely so is it 15 years, has been reading in Jamia Islamia Hafizia Madrasa at Dharamshala Passport since 2 years. However, on 10/4/2025, during close of madrasa, the below name accused number 1 called my daughter along with other girls to clean the madrasa and rise. The accused number 1 engaged the other girls to a separate place to clean and took my daughter at his office room, closed the door, have her forcefully touched her breast as well as tried to rape her.
Who are you? Accused number 1.
Sattar Ali, your lordship. Lordship, date of incident is on 10 April, your lordship. FIR was on 16 April, your lordship. There are 6 days delay, your lordship, without any explanation in the FIR, your lordship. No any cause of such delay, your lordship. And the victim is my granddaughter, your lordship. There is an earlier dispute of land regarding distribution of proportional share, your lordship. Totally false case, your lordship, just implication, your lordship. CD received it.
Yes.
My can produce the 183 statement, my lord. 180, 183 I have, and my lord, police says the one, my lord, that is birth certificate also. As per that, my lord, on the date of incident, my lord.
What is the age of the victim? On the other hand, learned additional public prosecutor Mr. K. Bosho has produced the case diary of Dhubri Sadar PS case number 208/2025 and has submitted that there are sufficient incriminating materials against the petitioner in the case diary, including the statement of the victim girl recorded under section 183 of BNSS. He has submitted that considering the nature of the offense, he has submitted that the petitioner is a minor.